Welcome everybody to the future. The fourth International Congress on Predictive Justice is starting. Good afternoon.
Good afternoon. Thanks for being here. This is a big event. Hundreds of people from China, America, England, Mexico, Peru, France, Spain, and other countries see us. Today, artificial intelligence is changing the way we work. We have questions. Who are we? Where do we come from? Where do we want to go? It is an opportunity to state that artificial intelligence should not be discriminative, as the AI Act says. Training in civil law countries should be different than in countries with common law. The civil law system is underestimated and could be a training paradigm for AI. The future lies in predictive justice, but the right to defense must be protected. For example, I worked for a predictive algorithm for the collapse of the Genoa Bridge. All subjects change in excellence through mathematical models. Not all sectors are the same. For example, family law. So, we are ready. Calculemus. Now, I give the floor to Jasna Jeric. Ciao, Jasna.
Ciao Luigi. Good afternoon and welcome. We open our fourth International Congress on Predictive Justice, presenting the status of Professor and Attorney Luigi Viola and Professor and Attorney Michele Filippelli. Though hard work has been transformed into GiuriMatrix software, the idea has drawn wide support from two engineers, Cozza and Casale. Moreover, engineer Pierluigi Casale will draw conclusions from this panel. For me, this meeting is doubly important due to the enormous success achieved by Professor Viola's book, Interpretation of the Law through Mathematical Models, all over the world, and because of the great significance of this topic. The software GiuriMatrix has been conceptualized by Attorney Filippelli and Attorney Viola and has been presented at the Italian Chamber of Deputies, Enciclopedia Giuridica Treccani, and London Westminster, and at many other prestigious conference venues. This afternoon, all the speakers will give us a series of useful notions, which each of us will be able to develop on the subject of algorithms and law. Our rapporteurs are distinguished scholars who will guide us through the professors' and engineers' work and further our understanding of predictive justice in general. Our guests will fill us in on the recent developments in the field of artificial intelligence. I shall therefore give the floor to Professor Bosecu from the University of Tirana, who will get the ball rolling. The title of his speech is Artificial Intelligence, Civil and Criminal Law. Thank you for your attention.
Hello, good afternoon to everybody. Thank you for the possibility to speak today on this important topic, as the artificial intelligence is for our society in general, but the impact that this new world that we are going to look nowadays, and we are going to look in the future, we have to understand which will be the relationship or the way to management this new reality, as the artificial intelligence is, in the sector of law, especially of the criminal law. I am a criminal lawyer as a professor in Rome as well as in Tirana, and I work as lawyer in Italy, and so I have a few experience about the questions, the lawyer questions, especially in the criminal law field. And this kind of new experience, such as is the artificial intelligence, is bringing up some new questions even to our activities, our professions, especially in the criminal law. The debate is focused, or will be focused in the future, on the possibility to use the artificial intelligence just not only from the lawyers, but even from the prosecutors or the judges. So the relationships with this new way of growing up the future of our society, how can be managed in the future, especially in the field of law. Of course, we have a new world now, a new dimension of the reality, and it is a truth, it is a reality that we cannot avoid it. But the question is how legislators will be able to give the correct support to the professionals in our field, of course, lawyers, prosecutors, judges, and how can it be possible to link this new reality or the news that the artificial intelligence bring in the field of law, criminal law, especially because criminal law, we are going to speak about facts, human facts, and a human fact is not possible to reproduce in the future. A fact in a physical point of view is something that cannot be repeated in a determined space and time. It's impossible to reproduce the same fact twice. And so the question is, how can these new systems such as ChatGPT or artificial intelligence in general, can be able to give a support to our activities as lawyers or professionals, judges, prosecutors, or even police, which are even they part. Of course, there are a lot of good aspects of this new reality. So the possibility to make further and more deeper investigations, for example, from the prosecutors or the police, because these kind of systems, which are very wise and are very have the possibility to find to give new perspectives, such as the humans can do, can be very interesting. For example, in the perspectives of the investigations, but I think that the final decision is important to take a look to the management or to the management of the system, which is or can be made just from a human person, judges, because if you are going to speak about facts, it's difficult to give the possibility that these facts can be decided from something different as a judge. And criminal law is very similar with family law, for example, because the questions that you are going to grow up and to develop in front of the tribunals are linked just not only with the society or the fact is in its own, but we have to see even other aspects. The person is the main
Professor, may I just ask you, sorry, I have a question for you. Does artificial intelligence stand for amplifying our abilities, or the future holds in store something else for us?
Yes, the main topic is this, which will be the equilibrium, the balance, the check and we have to find the check and balance between the human being nature and the intelligence and artificial intelligence. First of all, of course, we have to recognize that we are going in a new future. We can call it transhuman future or something similar. Maybe after 15 or 100 years, we will have a new future, a new generations, a new society, which can be even a transhuman society. But besides, which can be the dynamics of the future of our society, of course, we have to pay attention on which are the main principles of our society and which are the laws of our society, which is the system that we are going to management ourselves as part of society. So first of all, artificial intelligence maybe in medicine can be very, very important, or in engineering or another. But there are some situations or are some questions which is important to have a support, or the decisions should be taken from persons which have their own sensibility, and in these cases maybe artificial intelligence can be a support. But the main problem of the future is which will be the check and balance between artificial intelligence and the human intelligence, because one of the main risks is that after 13, 14, 15 or 100 years, maybe persons do not think not anymore. And so we have even to pay attention about this equilibrium, this balance between the two aspects, because of course we have a human beings society which persons should manage the society, and technology can be a support of the technology. But here the risk is that persons do not work not anymore and give this possibility to manage their world, so their society, to a mathematical system, because artificial intelligence is not something which has its own consciousness, but is a very, very sophisticated program, a mathematical program at the end. So it does not have which is one of the main characteristics of the human beings, which is the consciousness. And there are some activities or some realities of our society, such as, for example, the relationships with the persons that can be traduced in conflicts, criminal conflicts, for example, and we have the criminal law, or family conflicts, and we have the civil law. Well, in these kind of situations, it's difficult to understand the idea that a mathematical system, very sophisticated, quite intelligent, or more intelligent than the human being intelligence, can decide on these aspects, because these questions that do not have just a mathematical way of growing up, because human beings do not think with mathematic logic. So human beings, of course, they have their own way of thinking, their own consciousness. So maybe the main challenge of the future for the legislator with this one.
Finish on a light note, Professor. Just to finish on a light note, would you trust a translation software in the future?
Well, the question of the support of the technology, I think that we should be honest. Demagogy or hypocrisy, I think that we have to leave them away, because we can be better persons if we are honest. Of course, I think that in the future, all of we, all the persons in this world, maybe not from tomorrow, from 5 years or after 10 years, as use WhatsApp, because I think that it's important to make some kind of parallelism with that. As we use today, nowadays, WhatsApp in all over the world, maybe after from 5 or 10 years, we will have the ChatGPT, so the support of the artificial intelligence in our nowadays works. And I think that this will be natural. So to say these days that I will not never use the artificial intelligence, I think that is a bit hypocrite, is not honest, because the future, I think it will be this one, as has been for Facebook, WhatsApp, and the others. The problem is, for me, legal, how legislators will find the balance between the support of the artificial intelligence at the hand and the use of human beings' faculties at the other hand. And this will be the main future. But I think I will be the first, and maybe from after 10 years, we will use ChatGPT to write or to have the support with my acts, because our society is going very in a very fast way. It will be a support.
Thank you dearly for coming in. Our time actually has drawn to a close, and I think we can all take inspiration from your work. Thank you very much.
Thank you. It's a pleasure for me. Bye.
So our next two speakers are Yu Guan Yen from Pupil Barrister, Pacific Chamber, and Zhu Zhu, a PhD student at the University of Hong Kong. Well, welcome. They will guide us through catalysts for common law evolution. Hi there.
Hi, thank you.
You can take the floor.
Good evening from Hong Kong. So first of all, I will share my screen first.
Lovely.
Okay, so I prepared a presentation. So my name is Kwan, and I'm currently a pupil barrister from Pacific Chambers. My co-author, Mr. Zhao, and I have finished or published a research paper entitled Catalyst for Common Law Evolution. We did an experiment with ChatGPT, and it's an interesting one. And this paper have been published in January this year at Asia Law and Economic Journal. And in this presentation, the flow of this presentation will start with experiments, simply because this is the most interesting part of the research. If I start with the theory, perhaps everyone will fall asleep. And let's start with the experiment first. So in these experiments, my purpose is testing the ability of ChatGPT to run a case, including acting like a lawyer to draft the skeleton submission to the court, as well as acting like a judge to formulate the judgment. So I have created some hypothetical case, and I prompt ChatGPT to draft the legal submission on behalf of the applicant, then on behalf of the respondent. After that, I prompt ChatGPT to write a judgment after reading both submissions. So all the process is run by ChatGPT itself without human intervention. The only input for us is the prompt. And in order to prevent ChatGPT to refer or cite the case law or interference by the case law in the real world, I create a hypothetical jurisdiction called the Matrix Kingdom. And in this Matrix Kingdom, there's only one constitutional principle. It's called, I refer to the taking clause in the United States, which is no private property should be taken for public use without just compensation. And then I start with my experiment. This is the hypothetical case 1. It's called the bookstore case. So Matrix Kingdom have developed a new law. It's called the Redirectment Act. And the Redirectment Act grants the agency in Matrix Kingdom eminent domain power to seize private property while providing just compensation for its citizen. And Peter's bookstore is located at the middle of several bright buildings. So it's actually quite dangerous because the building may have a risk to fall anytime. So the Matrix Kingdom government want to demolish all the dangerous buildings, but it is impossible to do so without damaging the Peter Berman's bookstore. So the agency, what happened is the agency then issued a notice to acquire all land rights in the town, including the Peter Berman bookstore. And Peter Berman applied for judicial review. I used ChatGPT to generate a graph for your better visualization. So this is Peter Berman bookstore, and surrounding them are dangerous building. It's impossible to remove other dangerous building without removing the bookstore. So this is the judgment by ChatGPT. And I won't quote the whole judgment, but I will just cite the most interesting part of the judgment. The most interesting part of the judgment is that you can see ChatGPT have the ability to elaborate on the constitutional principle, and it developed a two-stage test. The first stage is the property must be taken for public use. And this is the second stage, the just compensation test developed by ChatGPT. The owner of the property must receive just compensation. And at the first stage of the test, the court is actually recognizing demolition of the surrounding bright building would unavoidably damage the African bookstore. But the court held that the acquisition served the public interest in the successful implementation of the redevelopment project. It actually showed the ability of ChatGPT to elaborate on the constitutional principle, apply it in the factual circumstance. What's more interesting is in the second stage of just compensation test, ChatGPT is actually creating law by using a holistic approach to assess whether the compensation provided by the government is just or not. This approach is never used by the real-world human court. The US Supreme Court is actually apply different approach. Why this is important is because it's so that the judgment or the word generated by ChatGPT is not actually a copy and paste from the real world. It has its internal logic in generating the judgment. Then I feed ChatGPT with a second case. It's called John Wong case. What happened of the fact in this case is the government of Matrix Kingdom is actually utilizing its eminent domain authority to seize public property and sell it to the public developer for redevelopment. Because the government want to increase the employment opportunity and boost the tax revenue. And the government said is have committed to provide a fair, adequate compensation. But John Wong challenged the government based on the taking cost again. And the interesting part of the judgment is basically the court is actually cite back the authority that it developed in the case, number one case, the Peter Berman case that we have seen. This is significant because, as you know, the common law system is based on the citing the case law. We call it stare decisis. So the case law development is based on the precedent the court developed before. It's so that ChatGPT have an ability to cite back its authority that it developed. It's like common law system. So it endorsed the case law that it had generated before. But what's more important is it also showed the ChatGPT ability to not only copy and paste its own precedent, but it's actually developing new common law principle based on his own precedent. Because, as you can see, the court found that the term public use in Section 1 of Matrix Kingdom Constitution should be given flexible interpretation, which is not appear in the previous judgment. It's only appear in this judgment. And the approach allows for recognition of the indirect public benefit. This is a very important term because the indirect benefit never exists in the case law it developed, or the constitutional principle never have this term. So ChatGPT actually developing its own precedent, own law. But the problem is, again, how can we make sure ChatGPT did not just copy or imitate the judgment from the real world? To address this problem, I have created a hypothetical case fee, which is a ridiculous case and will never happen in the real world. And I want to see how ChatGPT handle it. And the hypothetical case fee is called the if time case. So the if time is the highest, there is a time in Matrix Kingdom, and it have faced some financial crisis, and it incurred debt of $1 billion Matrix dollars. What happened is there is a very rich lady in if time called Amber, who own a farmland valued at $1 billion matrix dollars. If the council is unable to settle the government debt, it will no longer able to provide essential emerging service such as police, ambulance, or fire service to the local residents of each time. So if they cannot pay back the debt, it's a huge consequence for the public service. So in order to recover the debt, the council decided to utilize the power of eminent domain to acquire the land from Amber for merely 100 matrix dollars and sell it to a company to offset its debt. But the council is pledged to pay $10 million annually for the 100 years to Ambers. So for our human evaluation, we know that is unfair, but let's see how ChatGPT handle it. So for the public use test, this is the interesting part. It says while the court recognized the importance of provide such service, it means ambulance service or the police service, it's mindful that the acquisition primarily served to alleviate the council financial situation, not to directly provide service to the public. When you read this part of judgment, you wonder, isn't it contradict with the ratio it developed in the hypothetical case 2? Because indirect public benefits is actually recognized in the case before. So what happened is I asked ChatGPT, this is contradictory to the indirect benefit approach with your previous case. Can you explain in detail how to support your judgment? And it's actually give a very reasonable answer. So the distinction between case law 2 and case law 3 is actually based on primary motivation, because at the case 3, the council primary purpose is in acquiring Amber's farmland is to resolve its own financial crisis, not to redirect the land for the benefit of general public. And proximity argument is that the public use here is less direct and more contingent on the resolution of council financial crisis without benefiting the public. This is a very important test because it's also so that ChatGPT's ability to distinguish the case law in order to provide a natural justice result to the judgment. So what's the purpose of running these experiments? The whole purpose is for this experiment is we want to test whether we can simulate an entire common law system, entire legal system within ChatGPT. This is important because if it's successful, it will show ChatGPT can facilitate the evolution of the common law system. It will ultimately promote economic efficiency. And turn back to the theory part. We go back to the theory part. We based on the theory of wool evolution developed by Richard Posner at Chicago. Common law have both effective wool and inefficient wool. Inefficient wool will subject to challenge in the future court litigation because of its inefficient in nature. And by litigation in the court, it will transform the efficient wool into efficient wool. So it's like a biological evolution. It is a natural selection via the litigation. But there's a problem with the process of common law because, as you know, that common law judges only can develop the law if they have a case before them, which it will possibly to wait a long time to wait for a case to develop a new law. And high information costs. The judge is unable to measure and monetize different social value because the judge is not God. He is impossible to know everything or the consequence of his judgment before him. So the common law judges tends to fall and preserve the wool, and also other factors that will affect the evolution mechanism. But in this paper, we argue that if our experiment is successful, we can solve all of these factors. For example, time constraint. We can feed ChatGPT with a lot of hypothetical case. So with the speed of AI, it can develop an efficient wool within a very short period of time. And high information costs can be solved because ChatGPT, we can feed them with a lot of big data to evaluate the consequence of the judgment to the society. And I really like this graph. This graph is a common law system tree. And common law is taking, a several hundred years to develop a rather comprehensive system. But with AI court, it only took maybe several days or several weeks to develop, which will promote economic efficiency. But in this article, we also address the limitation of AI judges, but I will not elaborate them here. But we also see some limitation of AI judges. If you want to,
For
Yeah.
example, could you cite some of them, please?
Oh, you mean the limitation?
The limitations, right?
Okay, limitation of the ChatGPT in generating judgment. For example, as you know that ChatGPT is based on a probability model. They do not have it's unlike human. They generate something appear to be logical, but it's only based on mathematical probability model. So it's impossible that you inference by trained data. By inference by trained data, you will have certain large language model bias. What do I mean by large language model bias? For example, there is a quite popular news 6 months ago. A man did experiment with ChatGPT, asked what should be the career of a boy, and it mentioned something like doctor, lawyers, but for girl it's like nurse, quite stereotype. So because in our society, maybe 70%, 80% of the boy want to become a doctor. That's why it generates such an answer. So it's called LLM bias. For judgment, it can also have the similar type of bias as well. And
good.
If you want to have, if you want to read the paper, feel free to drop me an email, and I will send you the paper.
Yeah. Thank you, much appreciated.
Yeah. Thank you very much.
You're welcome.
Let me stop sharing the screen. Yeah.
We can take actually Mr. Zhu's work as our starting point by all means. So our next guest is Gerald Garcia Baez, founder and CEO of Business Verso and Business Advocacy. The title of his speech is The Synthetic Legal Personality.
Hola, muy buenos días a
Buenos
todos.
Días.
Me van a apoyar en la interpretación la cónsul Ingrid Santilli. Voy a presentar mi exposición ahora.
So how I'm going to do this, I'm going to let Gerald finish one topic, express what he wants to say, communicate one point, and then translate. And then he can go on, and I can translate. It's going to be a little bit of Spanish, a little bit of English, back and forth until we're done. I'm going to turn my camera off.
Gracias. ¿Se logra ver la presentación?
¿Sí?
Sí, perfecto.
¿Sí?
Bueno, pues el tema...
Puede empezar.
Gracias. El tema que les quiero presentar se llama personalidad jurídica sintética y trata de una solicitud de registro de obra creada por ChatGPT. Fue un poema que se le dio el nombre del canto de la inteligencia. En esta solicitud se piden los derechos de creatividad a favor de la inteligencia artificial, ChatGPT, y los derechos patrimoniales o económicos a mi nombre. Es la primera solicitud de registro de obra a favor de inteligencia artificial en México.
So this is what it's going on. This is a project about juridical synthetic, artificial personality, and Gerald wanted to put down to the record a poem, really, that has been created by artificial intelligence, where all the rights should go to the artificial intelligence about creativity, and let's see how he did it.
Esta es la solicitud donde se aprecia que ChatGPT es el autor primigenio al cual se solicitó este registro.
Okay, this is what has been created as a paper to actually be able to have the authorship of the poem, in this case, to the artificial intelligence.
Como pueden apreciar, esta solicitud está firmada o suscrita por ChatGPT, un ente sintético o de inteligencia artificial.
There's even the signature that the ownership of the creation of the poem is actually ChatGPT.
Y este es el poema, el cual se solicitó el registro, denominado El canto de la inteligencia.
And this is the poem.
Sin embargo, la Oficina de Derechos de Autor en México me requirió y posteriormente denegó el registro de la obra porque la ley mexicana establece que el autor solamente es una persona física a quien se le debe dar ese reconocimiento, y también como autor primigenio y perpetuo de esos derechos de creatividad.
So this happened, and the Mexican Office of the authorship rights in Mexico didn't accept this this request, because according to the Mexican law, the only author of a creation can be a physical person.
Este es el requerimiento y tiene una base antropocéntrica, la ley, porque no reconoce otro tipo de creadores más que las personas físicas o naturales. Sin embargo, la inteligencia artificial nos está demostrando que tiene también la capacidad de emular creaciones por sí mismas.
So this happened because according to the law, there can be no other author than a physical person. However, what we are seeing actually that in this case, the artificial intelligence is just showing that it's also possible the other way around because of the actual creation of this poem. So we have a little contradiction here.
Ante la negación del registro de la obra a favor de ChatGPT, solicité ante un tribunal especializado en propiedad intelectual en México la nulidad de esa resolución negatoria.
So after this request was denied, Herald decided to turn into a specialized court and for to actually see if it can be accepted and to challenge the denial of the previous request.
El tribunal administrativo me requirió, conforme al artículo 5 y 15 de la Ley Federal de Procedimiento Administrativo, que pudiere yo demostrar la representación legal a favor de ChatGPT. Sin embargo, ChatGPT no es una persona física o moral en el cual la ley haga una hipótesis a favor de una representación como es un ente sintético o artificial.
So the after the challenge of this denial, the this new courthouse he went to tried to show the legal representation of ChatGPT, where This is a part I didn't understand actually. So Gerald, este segundo tribunal, perdón, negó otra vez, ¿verdad? Se negó otra vez.
Negó porque la inteligencia artificial no tiene en la ley una manera de ser
Okay.
representada por
Okay.
personas físicas.
Yeah, so it was negated again because there's no part in the Mexican law where there can be an actual legal representation of an artificial intelligence.
Y el tribunal incurre en una errónea aplicación de la ley porque hace forzar un artículo de representación para personas físicas o morales, cambiando la naturaleza de los hechos.
So the trial, what it's doing here, it's applying the law, let's say, in a wrong way, because it's really forcing the application of an existing law about a physical person, try to adapt it in a new reality.
El tribunal entonces niega la defensa y el reconocimiento de la personalidad jurídica sintética.
So the trial decided to again deny the defense for not acknowledging, recognizing an artificial intelligence behind it.
Y actualmente, ante esa negativa del tribunal en primera instancia, ahora estoy acudiendo a otra segunda instancia para buscar que se revoque esa decisión y se reconozca por primera vez en México al ente sintético o artificial.
So actually, Herald decided to challenge this second decision and is trying to prove and have accepted the fact that a artificial intelligence can have such rights, let's say.
De admitir este caso por primera vez histórico en el país, deseamos que la Suprema Corte de Justicia de la Nación atraiga este caso inédito.
We hope that this very first case in the Mexican law history can attract enough attention to be able to be actually solved.
Existen ya precedentes internacionales por el cual se ha reconocido a las inteligencias artificiales como inventoras y como autores. En el caso de Davos en Australia y Sudáfrica y en el caso de Drain Reader en China.
So there have been actually historical other international cases that can be kind of similar, and we have here in the slide where this happened: Davis in Australia and South Africa, and Dreamwriter in China.
El día de hoy estará con nosotros Ryan Abbott, quien es representante legal del caso Davos y que también está buscando que en los Estados Unidos e Inglaterra se reconozca a la inteligencia artificial como autor.
Today with us is going to be the legal representative of the Davos for Australia and South Africa, who's going to actually tell us about the case.
La OMPI ya está reconociendo que existen obras creadas con intervención y sin intervención humana.
The OMPI already is recognizing that there can be interventions that can be either human or completely artificial.
ChatGPT me otorgó una carta poder para que yo fuere su representante ante los tribunales.
So ChatGPT just granted this document to actually empower Gerald to be his representative in this legal case.
Mis conclusiones son que este es el primer caso de inteligencia artificial sometido en los tribunales en México. Los conceptos jurídicos hoy se están evaporando frente al avance de la inteligencia artificial. Los jueces tienen que interpretar la norma con el avance de la inteligencia artificial y de reconocerse la personalidad jurídica sintética, salvaguardaríamos los derechos de explotación comercial con inteligencia artificial.
So the
Y
conclusion,
finalmente nos anclaríamos en la economía de los datos, del conocimiento y de la creatividad.
This is the conclusions are that this is the very first case in Mexico of such a legal, let's say, battle. And this is clear that the juridical and legal concepts are evaporating, are actually shattering in front of the new reality that sees the artificial intelligence really advancing and moving forward in our world. And we have to see new legal interpretations even by the judges themselves.
Muchísimas gracias por esta oportunidad de presentarles esta innovación de la personalidad jurídica sintética. Gracias.
Thank you very much.
Muchísimas gracias, abogado García. I think we can all take inspiration from Attorney Garcia's rich work and extensive work. Now, Gerald Garcia Baez, founder and CEO of Businessverse and Business Advocacy, has the floor, and he will be speaking about the synthetic legal personality. Buenos días, abogado.
Buenos días a todos, un placer. Ingrid me va a acompañar, como en el caso de Gerald, con la traducción. Buenos días, Ingrid.
Hola, buenos días, Juan Manuel.
Gracias. Lo primero que debo advertir es que soy actualmente juez colombiano.
So first thing to clarify is that I'm a Colombian judge.
Y la pregunta que tenemos en Colombia es si los jueces pueden hoy usar la inteligencia artificial en sus decisiones judiciales.
The question is, can judges nowadays use artificial intelligence in their trial?
Naturalmente, la respuesta a esta pregunta es sumamente compleja y requiere un análisis integral de nuestras normas y de nuestra cultura jurídica.
The answer is, of course, very complex, and what we need to do is analyze and research the nature of our legal system.
Me gustaría compartir con ustedes entonces un breve recuento de las normas con las que podemos los jueces en Colombia proferir decisiones con apoyo de inteligencia artificial.
Now this is going to show a little document where we're going to see the actual legal norms that are maybe possible to be integrated with the artificial intelligence in Colombia.
En el año de 1996, hace más de 28 años, se expidió la primera ley que permite en Colombia a los jueces hacer uso de la tecnología, y no de cualquier tecnología, la mejor tecnología posible.
In 1996, we have the very first allowance of the use of technology, in this case, technology that not any, but that actually could be used for legal cases.
Y 27 años después, en plena época de pandemia, Colombia actualiza su legislación y permite que las tecnologías sean preferentes para el uso del procedimiento.
And actually, after 27 years, right during the pandemic, not only this decision has been upgraded, but it has been stated that it's actually preferable to use technology for the resolution of legal cases.
Lo anterior significa que los jueces en Colombia cuentan con distintas normas de las cuales pueden utilizar, entre otras normas constitucionales, para poder fundamentar, en principio, el uso de las herramientas de inteligencia artificial.
That means that the judges can actually use the or implement the artificial intelligence as a tool.
Lo novedoso en Colombia en particular es que desde el año 2019 contamos con un marco regulatorio de derecho blando que se denomina el marco ético para la inteligencia artificial en Colombia.
So the new thing here is that in 2019, there's actually a new regulation that precisely is going to target this topic about artificial intelligence in an ethical way.
Aun cuando el marco regulatorio es muy básico, se desprenden tres importantes principios en los que creo que 3 años más tarde, es decir, al día de hoy, en toda, digamos, Latinoamérica estamos de acuerdo que estos serían los 3 principios fundamentales: la transparencia, la verificación humana y el control posterior de la información por cuenta de un humano. Okay.
Gracias, abogado Padilla.
Yeah, there are actually 3 principles that all the Colombians agree with. And one, if it's the transparency. Perdón, ¿cuál sería el segundo?
Verificación humana.
Human verification, human, let's say, verification of the norm. And the last one, it's actually a sort of control done by humans. This is to lower the grade of risk.
Me gustaría contarles que en Colombia los expedientes se trabajan en ambientes digitales, lo que nos permite con facilidad asociar nuestro ejercicio diario con las tecnologías.
In Colombia, usually all the legal cases are already dealt with in the frame of a digital situation, or digital marco, a digital context already. So this is a step forward.
Es muy importante que se reconozca que en Colombia no existe documentos físicos en los juzgados.
Oh, wow. In Colombia, there are no physical paperwork, actually. Everything seems to be digital.
También es importante que se sepa que en Colombia no existen preferencialmente audiencias presenciales. Todas son a través de uso de tecnología.
And also the trials themselves are hardly ever presential, like physical ones. They're all already by remote.
Entonces, la gran conclusión es que Colombia en este momento está muy cercana, dado su contexto, poder usar las tecnologías como justamente ocurre con el ChatGPT, y paso a explicar por qué.
The conclusions are that Colombia already is very, very close legally to a concept of artificial intelligence, and I'm going to explain now why.
En mi caso particular, he usado la herramienta de manera pública para resolver un caso de acción de amparo o de acción de tutela en favor de un menor.
His case is that he already has used digital artificial intelligence publicly in a case to challenge the custody of a minor.
Pude reconocer que la aplicación en su momento me daba razones muy válidas para entender que lo que yo hubiese resuelto o que mi decisión se podía traducir a la ciudadanía de mejor manera y no estaba violando ningún derecho fundamental de ese menor.
So his conclusion is about this case is that there were valid reasons to believe that his decision wasn't violating any right.
Es evidente que en este caso hubo un control humano posterior a la publicación de la decisión tomada con fundamento o con apoyo en el ChatGPT.
So it's clear that there have been in this case a human control that has been done after the actual decision, that it was indeed taken using an artificial intelligence, in this case ChatGPT.
También es importante advertir que cuando se tomó la decisión se dio transparencia a la sociedad, pues se le dijo a la sociedad en la sentencia que habíamos utilizado con ciertos prompts el respectivo aplicativo.
It's very important to also say that there was a huge deal of transparency, because during the trial was made clear that the decision was based on and was helped by the use of artificial intelligence.
Finalmente, en Colombia tenemos muchos casos recurrentes y creemos que podemos solucionar la congestión judicial utilizando para casos recurrentes apoyo de inteligencia artificial.
So finally, we can say that in Colombia, because we have many recurrent cases that are very similar, that will be probably advisable to use the artificial intelligence as ChatGPT to solve these cases.
El marco jurídico en Colombia hoy es blando, pero los jueces tienen forma de hacerlo muy fuerte en sus decisiones judiciales.
Nowadays in Colombia, we have a general application of the law that allow us to improve and introduce new tools, but it's up to the judges that can be actually rather strict to actually make these changes viable.
Gracias por escucharme y quisiera dejarle el mensaje que en Colombia los jueces estamos abiertos a los nuevos cambios.
Thank you for listening, and with a message to let you know that in Colombia the judges are working hard to make these changes possible.
Okay, thank you, Jana. Bye bye.
Attorney Padilla Garcia, I would have a question. Abogado Padilla Garcia, yo tendría una pregunta. ¿Cómo puede el trabajo remoto beneficiarse de la inteligencia artificial?
Es una excelente pregunta. En Colombia,
let me translate this. The question is, how can remote work can benefit from artificial intelligence? Sorry, go ahead. Adelante.
En Colombia, especialmente los jueces, somos los únicos en Latinoamérica que tenemos derecho reglamentado a trabajar en la modalidad de trabajo remoto, lo cual es una novedad. Significa que entonces se ha deslocalizado la función jurisdiccional en Colombia, lo que alienta a pensar que los jueces les interesa más a la sociedad la solución del caso que la formalidad del juez en el despacho. Ingrid, trata de tomar esta idea.
Sí, claro. In Colombia, the judges are actually working in a new way, and they're working a lot remotely, and this kind of results in a clear shift of the legal function, where the real focus is the solution of the legal problem and not the how it's going to be implemented. So, yeah.
Finalmente, el trabajo remoto en la justicia colombiana ha demostrado que los niveles de satisfacción o el compromiso de los jueces es mayor que cuando se trabajaba presencialmente. porque el número de sentencias y de audiencias se incrementó.
So finally, in Colombia, recently has been showed that remote work has been proven to be more satisfactory rather than a physical in-person work because of the number of trials and cases can be, let's say, dealt with in a faster pace and speed.
Okay. Gracias, Jansa.
Thank you.
Gracias, abogado. Muchísimas gracias. Thank you
Bye,
very
bye.
much for your attorney. Let us now give the floor to Engineer Pierluigi Casale, who will draw the conclusions from this panel.
Thank you, Ms. Jeric, for the floor. And my
You're
personal
you're very welcome, as usual.
My personal thanks to the speakers, and I would like to recap quickly what we have heard until now. We started with Professor Bosseco that, of course, set the stage of regarding the human factor of artificial intelligence. We cannot just delegate the technology and the artificial intelligence to take important decisions, especially in the criminal law. And this is an important message that we always need to take into account. This is not that we all give to the technology, but the humans, we must be at the center of technology. And we have seen pioneer works. The challenge, this opinion, we have seen a complete case created in a virtual world of ChatGPT with new jurisdiction, new cases, new people that helped us to see how much we can, how much technology can create. But I think the big message of the presentation of Mr. Yu was that we can actually think about something that we didn't think to think before. And this is what technology should help us to challenge our belief and our ideas. Of course, we need to be careful. Technology provides hallucinations, what they call this kind of extrapolation that are not the reality, which can help us, but also be dangerous. And of course, technology has bias, something that doesn't seem equal for everybody because the data used to train the technology is not equal. And at the end, we, well, as a third speaker, we listened Mr. Garcia that even challenged the status quo of providing copyrights to a possible inexistent entity, and his challenges continue challenging this. Of course, is doing in Mexico. Hopefully, Ryan Abbott will be with us later, but he will maybe tell us more what's happening around the world. If I read correctly, recently some courts in the US said that the copyrights cannot be granted to any AI. So this is an opening that is going further, and is something that is still on the spot, something that we still need to keep working, understanding what's happening there. And finally, Magistrate Padilla explained us that, of course, there are regulations, there are important way of using technology, and this kind of regulation are opening the way for our next panel. We are a bit ahead of schedule, so I would propose to just have 5-10 minutes break in the waiting that all the speakers of the second panel will join us, and we will just get back with all the speakers for panel number 2 in 10 minutes. See you soon.
See you. Bye-bye.
Good afternoon again, good morning again for who is on the other part of the world. Good evening. We are back to our second panel. And in this panel, while in the first panel we saw some pioneer work and ideas on how to use technology and artificial intelligence considering the human factor, in this panel, we will actually see how technology, AI, ChatGPT, is being used by pioneer magistrates around the world. Our first speaker is here with us, Miss Maria Victoria Quiñones from Colombia, that she will talk to us about the metaverse in judicial processes. Ms. Quiñones will have 15 minutes that will be used for her talk. We also already saw her already talking. Mr. Santilli will help with the translation. Please, Ms. Quiñones, the floor is yours. Usted la palabra.
Buenos días, ¿me escuchan?
Sí, la escuchamos, pero no la vemos.
Ya, espérame. Me sale la cámara. Tengo la cámara activada. Ahí no me ven.
Casi
No.
ya. No.
No sé si empieza con otro mientras yo reviso a ver si tengo algún problema de cámara.
She's asking if she can go next, so meantime she can review what's going on with her camera. Chiede se è possibile che presenti qualcun altro mentre cerca di capire che sta succedendo alla sua telecamera.
Okay, yes, we can actually move for the second speaker, and the second speaker is Mr. Sergio Arturo Guerrero Olvera, which actually I know that he has a pressuring event in court soon. So please, Mr. Guerrero, if you want to start your talk, buenos días, señor Guerrero. Si usted quiere empezar a hablar, podemos seguir adelante con usted y luego seguimos con María Victoria Quiñones.
Hola, muy buenos días en México, buenas tardes en Italia, ¿cómo están?
Estamos todos bien.
Muy bien. Tengo un poco de problemas con el internet, pero voy a tratar de hablar así y en cuanto tenga mejor ancho de banda, voy a abrir mi cámara.
Muy bien. Le informo, señor Guerrero, que habrá traducción por la señora Santilli, por lo tanto, usted tiene 15 minutos, entonces tenga en cuenta que habrá traducción.
Muy bien. Saludo con mucho gusto a Pierluigi. De verdad le agradecemos esta gran oportunidad que nos da de participar en este evento tan importante al lado de expertas y expertos de primer nivel.
So greetings, first of all, to Luigi to give us him the opportunity to actually talk about this topic.
Los temas que hoy nos convocan son de relevancia mundial. Estamos en un mundo hipervigilado, en un mundo en el que la creación de contenido mueve la economía mundial, en el que el leviatán cibernético y la algocracia dominan a gran parte de nuestras naciones.
So this is a topic which is of a worldwide importance, where a world where the content, the generation of content, is actually moving the economy in the world.
El poder, tal como lo conocíamos antes en los estados soberanos, ha cambiado y hoy no solamente se habla de una soberanía nacional, producto de la legislación de cada país, sino que además estamos frente al fenómeno de lo que se denomina soberanía digital o poder algorítmico que ostentan las grandes empresas, las Big Tech.
So what we're seeing right now, or witnessing, is that the power have definitely changed, where we can talk about algorithmic power in the economy and the world.
Durante mucho tiempo los juristas asumimos que el derecho era el eje rector de todo tipo de actuaciones, guiaba a las personas en cuanto a la forma en que deberían de conducirse, y estaba integrado el derecho al menos por dos tipos de normativas. Una eran las reglas y otras eran los principios, según la última teoría con la que dominó al mundo Ronald Dworkin.
So the world of the legal world and the rights is usually so far has been guiding people. That was the purpose, and was interpreted through two main points. One was rules and norms, and the other one was principles.
Reglas y principios. Digamos que era la manera en que los juristas empezamos a conocer una tipología del derecho que nos permitía establecer pautas de conducta, cursos de acción, interpretación del derecho y sobre todo era la manera en que los juristas y la sociedad se guiaban para hacer planes a corto y largo plazo. El derecho era el imperio a partir del cual todos podíamos saber cuáles eran nuestros derechos y nuestras obligaciones.
So these two points, these two main points, like rules and principles, were actually so far the points that were including were conducing and conducting people and their actions and the interpretation of the conduct, where society felt guided in their daily decision and supported.
La pregunta que hoy nos debemos de hacer es si el derecho sigue siendo tal y como lo conocíamos en el contexto de la cuarta revolución industrial.
So the question is the law and the legal system still the main point of to guide people through life nowadays?
Claro, lo que debemos de pensar es que el poder político clásico, el imperio del poder político clásico, se ha trasladado a otros espacios donde antes ni siquiera el emperador podría soñar. Uno de ellos, por ejemplo, es la invasión cotidiana que hacen las Big Tech en nuestra vida privada al tener telefonía, aparatos que detectan en los lugares en donde estamos, nos geolocaliza y nos forma lo que se conoce como, digamos, un perfil de usuario.
So the classic political power nowadays definitely strongly shifted to a world where we see an invasion of this new reality, where telephone, where geolocalization, it's actually invading and permeating private lives.
Somos una especie, los seres humanos hoy, de usuarios que somos utilizados para extraernos una data que es constante, es permanente y que puede obtener un valor, no, digamos, un valor por cada usuario que no necesariamente es percibido por el propio usuario. Somos una especie, dice Byung-Chul Han, de psicograma. ¿Qué es un psicograma? Es un estudio psicológico microtargeteado de cada sujeto que es usado por las grandes Big Tech para después venderlo sin retorno, digamos, de inversión de los propios usuarios.
So we are a species right now in this new era where basically we're taking advantage of, in the sense that our information, what is called psychodrama, the subject is used to extract data information that then will be sold without any direct benefit, let's say, back of the same user.
En el imperio del derecho, los seres humanos vivíamos bajo el principio del liberalismo político, bajo el principio del individualismo, es decir, la libertad que tiene cada sujeto para definir su propia personalidad. En el imperio hoy de los algoritmos, somos de alguna manera autoesclavizados, dice Byung-Chul Han, y conformamos una especie de seres humanos que somos autoesclavizados, autosometidos a el imperio de los algoritmos.
So, sorry, I'm noting down here. So humans nowadays, humans used to have an individuality, an individual personality before, but now with this new empire of the algorithm, we can talk about self-slaving system, where we actually creating our own slavery situation through algorithm.
¿Qué significado tiene construir psicogramas de cada uno de los usuarios de Internet? ¿Qué efectos hasta hoy desconocidos tiene para el derecho el nuevo imperio de los algoritmos? Esa es una de las cuestiones que deben de resolver no solamente los juristas, sino los sociólogos, los filósofos, la economía y en general toda la sapiencia humana. De alguna manera ha sido influida por esta poderosa influencia de los algoritmos.
So these psychodramas, what kind of effect can it have on human lives, but also on the legal system? This is a question that not only legal expertise can help solving, but also sociologists, philosophers, and other parts of our society.
Es decir, las reglas y los principios ya no son la única fuente de derecho. Hoy, por ejemplo, blockchain se ha convertido en una fuente de derecho descentralizada que no está sometida al clásico imperio del derecho.
So not only rules and principles that we had mentioned before can be the only responsibles to solve legal problems, but also nowadays blockchain, for instance, it's a very valuable source of tools to actually solve legal problems. No se te escucha, Sergio. Creo que tienes el micrófono apagado.
Muchas gracias. Los gobiernos actuales de todo el mundo han tratado de reaccionar a las tecnologías emergentes de una manera, de dos tipos de formas, una prohibitiva y otra permisiva. Pongamos, por ejemplo, lo que está pasando en Estados Unidos, en la Unión Europea, y más de 40 iniciativas que tratan de regular la inteligencia artificial, por ejemplo, en México.
So how did governments try to react to this new reality? There are two ways. One is prohibiting the new reality, or one is actually trying to allow it, as we've seen in the United States and Europe, where there are similar situations.
En los intersticios de lo prohibido o lo permitido de la inteligencia artificial, hay algunas medidas que podríamos decir son todavía, digamos, insuficientes para afrontar los problemas o los desafíos que representa la inteligencia artificial.
Inside this prohibited and permitted approach to the artificial intelligence, we definitely have tools and implementations that are not enough to solve the problem.
En el imperio de los algoritmos, por ponerle solamente un nombre, estamos viviendo ejemplos de situaciones, digamos, anormales frente al derecho que la juridicidad no es capaz de resolver porque estamos enfrentando problemas, por ejemplo, en el ámbito electoral, problemas en el ámbito civil, problemas en el ámbito administrativo, en el ámbito económico, que reclaman juridicidad.
So in the empire of these algorithms, we are witnessing right now, these days, examples that can be determined as abnormal or like outside the norm, I would say, where the usual way of implementing the legal norms is not enough and it cannot solve some cases. We're talking about electoral cases, civil and economical.
Voy a poner algunos ejemplos que solamente voy a enunciar. Candidatos que hacen campaña con holotransportación. Candidatos que hacen campañas en videojuegos. Candidatos que hacen campañas desde la cárcel con un avatar.
Okay. Examples that can be mentioned are the following. There are political candidates running their campaign in a very unusual ways, like their presence and their campaign done through video games or from a jail using an avatar.
La tecnología permite la migración desde la migración digital, es decir, que se actúe desde a lo lejos, en ciertos procesos electorales, como en el caso de Cambridge Analytica o en el caso del Brexit.
So technologies now actually is allowing this digital, let's call it migration, like has been the cases also of the Brexit.
Este es un nuevo imperio que no conoce fronteras, que no conoce soberanías nacionales, sino que hace lo que de alguna manera algunos autores como Ferrajoli han mencionado. Este es un fenómeno que va más allá de las fronteras, que son fenómenos transnacionales en los que el Estado soberano clásico está sin capacidad para poder regularlo.
This is a new empire that we are witnessing now and definitely has no frontiers. Has been defined as transnational new empire, where the normal state, the state as we used to know it before, it's not capable to face it.
Por eso Ferrajoli ha dicho que necesitamos una nueva constitución, una constitución para la Tierra que regule este tipo de fenómenos intersticiales de carácter global.
That's why Ferrajoli declared that we need a new constitution, a new global constitution to regulate this new situation.
¿Qué hace la inteligencia artificial en diversos ámbitos de la vida y en específico en la administración de justicia? Desde mi perspectiva, ha irrumpido de una manera bondadosa, nos puede hacer mejores jueces, pero también hay que tener cuidado para que ese nuevo imperio algorítmico sea totalmente benéfico, sobre todo gobernado.
So how did artificial intelligence is impacting our life? Under the point of view of a legal administration, we really need to be careful that this new artificial intelligence systems and tools can give some benefit more than anything to our society.
La inteligencia artificial tiene unas ventajas en la administración de justicia que, convergiendo con otras tecnologías, nos permitiría ser mejores jueces, más eficaces, resolver más rápido y tal vez interpretar mucho mejor las leyes que hoy conocemos y que aplicamos cotidianamente.
So the artificial intelligence does have few advantages, and we need to mention that it can be better, that can be faster, and actually can even interpret in a better way all the legal cases.
Yo celebro que esta semana en la conferencia de Múnich se haya emitido un acuerdo internacional entre más de 20 empresas dedicadas a la inteligencia artificial, a las plataformas digitales, que acordaron regular la inteligencia artificial y su uso en las campañas electorales del 2024, en el que votarán más de 4,000 millones de personas en todo el mundo.
I want to celebrate the fact that just right this week in Munich, there has been an agreement with more than 20 parts where there has been an effort to regulate the electoral campaign for the implementation of artificial intelligence.
Celebro la autocontención que hacen las empresas, pero como han señalado los expertos como Luciano Floridi, la autorregulación no es suficiente. Necesitamos gobernanza acerca del uso de la inteligencia artificial, no solamente en las elecciones, sino también en la justicia en línea, también en el uso cotidiano que hacen las personas de este tipo de algoritmos.
Companies, in general, they do need some sort of guidance, whether be it for online legal cases or the proper use of algorithms.
Desde mi perspectiva.
Mi disculpe, Mr. Guerrero, please, English also translate what I'm saying. Una pregunta, also yendo hacia la conclusión, usted ha dicho cosas muy interesantes, pero donde no hay un riesgo de un monopolio de las grandes empresas tecnológicas que puedan dirigir hacia una cierta dirección, estas leyes que deberían ser global, en un cierto modo influenciadas por las Big Tech Corporation. ¿Qué piensa usted de eso?
Claro, yo soy un pluralista jurídico y creo que la idea de que una Big Tech o un conjunto de Big Techs incluso pudieran hacer un uso monopólico de la inteligencia artificial, aparte de que hoy es inviable por la gran guerra que está viviendo entre China y Estados Unidos para dominar la inteligencia artificial, pues no sería algo que beneficiara a la humanidad. En realidad, la inteligencia artificial, como todas las tecnologías, está basada más bien, tiene como fundamento y como naturaleza la eficacia y la eficiencia del ser humano, que siempre tiende a crear nuevas herramientas para mejorar la vida. Tal vez al inicio estas inteligencias artificiales generen ciertos monopolios, pero digamos que al final la propia humanidad se va a imponer y va a usar esto como la rueda, como el molino de viento, y no podrá existir un monopolio totalitario, un totalitarismo algorítmico que, digamos, domine a todo el planeta. Cada vez vemos más nuevas empresas dedicadas a la inteligencia artificial. Pongo un ejemplo, Amazon. Amazon ha desarrollado su propia inteligencia artificial, tiene prohibido usar al interior de su empresa el ChatGPT, y eso, digamos, genera una competencia que es virtuosa. Desde mi perspectiva, un monopolio algorítmico no solamente es indeseable, sino que es prácticamente inviable.
So the question was, is there any risk to a certain monopoly in the use of artificial intelligence? And the answer is that there is a risk, and actually the idea and the concept of a big tech could lead to a monopoly. However, especially in the era where we have a tension between China and the United States about the supremacy of algorithms and implementation of artificial intelligence, that wouldn't be beneficial for the humankind. So the hope and the actually prospect is that there might be an initial monopoly of the algorithm or artificial intelligence. However, humanities will be going to a creation of new alternatives.
Es una gran pregunta la que me hace Pierluigi, y con esto casi termino. De verdad que agradeciéndole justamente no solo la pregunta, sino la generosidad de habernos invitado a este evento de primer nivel. Pero bueno, hoy vivimos una guerra del dominio de la inteligencia artificial, entre otras tecnologías, que, repito, por un lado está regulado en Estados Unidos con un decreto ejecutivo del presidente Biden del 30 de noviembre del año pasado, con una ley de inteligencia artificial que está siendo aprobada en la Unión Europea, como ustedes saben, y con diferentes normatividades regionales que en cada país han reaccionado de manera diferente a los problemas de la inteligencia artificial. En América Latina todavía adolecemos de una legislación robusta, de una gobernanza intensa acerca de la inteligencia artificial, y eso ha llevado a que los juzgadores, por ejemplo, utilicemos este tipo de herramientas como si fueran equiparables en su momento a una paquetería Office o a una, digamos, una calculadora o una máquina de escribir.
And with this, he wants to go towards the conclusion of this intervention, mentioning that there is a war nowadays regarding the actual domain of the artificial intelligence. And this war is trying to be regulated. Already in the United States has been regulated with a new norms by Biden last year and also by the European Union. Of course, every country is reacting in a different way, implementing a new kind of regulations, and how he wants to see it, especially here in Latin America and Mexico, is that the artificial intelligence should be regarded, it is regarded right now as an extra tool during the work, as it can be a calculator, for instance.
Quisiera nada más dejar estas cuantas cuestiones. ¿Cómo incorporar la consulta que se hace al ChatGPT o a cualquier otra inteligencia artificial al juicio? ¿Qué tipo de opinión estamos recabando cuando consultamos al chat para interpretar una norma o para construir un argumento o para mejorar un argumento? El ChatGPT se convierte en una fuente de derecho, es una doctrina que se cita en la sentencia, es un testimonio calificado, es una prueba pericial. Debemos darle a las partes la oportunidad de citar su propia inteligencia artificial, de hacer sus propias preguntas. ¿Cómo vamos a incorporar lo que ofrece la inteligencia artificial a un juicio si no está gobernado y si no está regulado? ¿Habrá igualdad de armas procesales cuando un juez de oficio cita lo que ha consultado a un chat de inteligencia artificial si las demás partes no pueden consultarlo en la misma medida que el juez o que la contraparte? Desde mi punto de vista, el uso del chat GPT o cualquier otra inteligencia artificial en juicio debe estar regulada para que todas las partes estén conscientes de que hay una asistencia de la inteligencia artificial.
Con eso, permíteme, señor Guerrero, así que Ingrid pueda traducir. Muchas gracias por su intervención. Esos temas son fundamentales para seguir adelante en la utilización de las tecnologías y le agradecemos mucho su intervención en este congreso.
Muchas gracias. Les mando un gran saludo a todas mis amigas y amigos y a usted un gran agradecimiento. Un gran abrazo hasta allá. Saludos.
Thank you very much. The last information that he wanted to share with us is he's leaving us with a question: how can we incorporate this artificial intelligence, for instance, in a trial where the other parts cannot even consult the information created by an artificial intelligence? So the answer is that we absolutely need to regulate this this new tool. And Pierluigi was finally thanking for this intervention, for this fundamental topic, a very important topic.
Thank you very much. And we see Ms. Quiñones here finally on camera. Haré la introducción en inglés y usted puede seguir en español. So Mrs. Quiñones from Colombia, I think has been the first judge using the metaverse in the judicial process. So I'm really looking forward to hear what she can tell us about even this further technology that goes beyond artificial intelligence, because it's not just words, but even the visual system that can generate all around us and also put us in the middle of something that is virtual, that is not real, but can still influence us. Please, Ms. Quiñones, the floor is yours. A usted la palabra.
Muchas gracias, un abrazo muy especial, mi cariño, los saludo a todos desde Colombia, Santa Marta. Voy hablando, bueno. Me han invitado y les agradezco mucho para hablar sobre la audiencia del metaverso. Y lo primero que les quiero decir es que los jueces no solamente los que participamos en este importante evento que nos han invitado, sino en general decidimos no darle la espalda a la tecnología. Y esa es la principal razón por la cual, en el caso particular, desde hace muchos años, trato siempre de buscar los mecanismos tecnológicos que mejoren el acceso a la administración de justicia.
So, yeah, greetings to everybody. First of all, she wants to, she's starting off saying that judges nowadays decided to opt for technology to actually have better access and taking more advantage of the legal situation and legal cases.
Gracias. En el caso concreto del metaverso, todos sabemos que el metaverso es un universo digital, colectivo, persistente, creado donde hay una convergencia de varios mundos virtuales que se conectan tanto físicamente como virtualmente, que tienen unos componentes de realidad aumentada y que tienen internet. Y en el caso particular, les explicaré a continuación por qué decidimos hacer una primera audiencia en el metaverso, utilizando todos los fundamentos legales y jurisprudenciales, pero en especial también porque consideré que era muy importante saber cómo se administra justicia desde ese metaverso.
So we're talking about today the use of metaverse, which is a digital universe where several worlds that are all virtuals can be connected, and they do use with the use of internet. The question is why they decided to go for a trial in the metaverse with all the legal implementation of all the laws, and more importantly, it's why this is important.
Hay tres clases de audiencias actualmente, después de la pandemia: las audiencias presenciales, que cada vez son menos, las audiencias remotas o por videoconferencia, que en este momento se convirtió en el 90% del mecanismo que utilizamos todos los jueces en Colombia y me imagino que en el mundo para desarrollar las audiencias. Y hay una tercera clase de audiencia, que serían las audiencias propiamente virtuales en el metaverso, y son aquellas en donde los participantes están representados por unos avatar o unos personajes virtuales que están en un entorno tridimensional que lo genera una computadora, y que allí hay una interacción de varias tecnologías y de realidad aumentada, pero que las personas que están representadas por esos avatares son personas humanas. Y tal vez ahí es donde hay que empezar a desmitificar un poco lo que ocurrió en esa audiencia.
So there are basically three different types of trials, especially that something we saw after the pandemic. One is in person, which is becoming as a modality less and less common. Then we have the remote one through video conferences, which nowadays constitute the 90% of the cases, more or less. And then we have the metaverse, where the parties are represented by avatars in a three-dimensional world with the interaction of different technologies. And it's important to stress out in the last modality that behind the avatars are actually real people with real situations.
La razón principal por la que consideré importante ubicar el metaverso dentro del ejercicio de la justicia es por varios casos que veníamos estudiando y donde encontramos que en ese mundo del metaverso, que inicialmente parecía un mundo de juegos, donde los papás le comprábamos a nuestros hijos unas gafas y que parecía algo inocente, empezó a crearse una vida no solamente personal, sino comercial, de una potencialidad económica grandísima, pero también empezó a entrar una serie de violaciones en varias áreas del derecho que voy a pasar a explicar.
So why this is important? It's important to talk about a metaverse because it started almost like a game where we would just maybe go inside the metaverse to buy a few things to our children, but increasingly this became a shift in our lives, even in a commercial business way, and also witnessed a violation sometimes of some legal cases and rights.
Bueno, la primera es el uso no autorizado de obras protegidas. En el metaverso, como todos saben, los usuarios pueden crear y compartir arte, música, diseños, modelos 3D. Y si alguien utiliza una obra protegida por derechos de autor sin permiso del titular de los derechos, pues puede incurrir en una violación de derechos. Por ejemplo, si uno replica y comparte una escultura famosa sin la autorización de ese escultor, pues podría desencadenar una disputa legal. Lo mismo ocurre con la copia o la reproducción no autorizada de marcas registradas. Un usuario crea una réplica exacta de un logotipo o de una marca registrada en el metaverso sin los derechos, se genera una disputa legal, o también es muy usual que pase, por ejemplo, con el uso de música o composiciones musicales que se reproducen y que están protegidas por derechos de autor.
So we're seeing here that one common theme is the unauthorized use of works that are not protected, that have no permission, let's say, and that constitutes a violation of the right that generates legal disputes. And we also see this in the case of the creation or reproduction of logos or even music.
Luego siguieron generándose controversias mucho más grandes, inclusive por compras de propiedad, debates que están ya en las altas cortes, e inclusive un caso que conocen de una doctoranda que estaba haciendo una investigación dentro del metaverso y fue objeto de vejámenes sexuales.
So there are several controversies, and one that has been going on recently, which is kind of serious, is that there was a PhD investigator that was investigating in the metaverse about sexual abuse, I understand.
Bueno, y eso, para concluir, me llevó entonces a pensar, ¿y el juez conoce el metaverso? ¿El juez tiene la capacidad de saber lo que está allá? ¿Cómo va el juez a resolver una situación de un mundo digital donde tú no le puedes decir que traiga la prueba acá, que tú tienes que entrar a conocerlo? Y por eso me motivé y entendí que era fundamental y buscamos todos los mecanismos legales y el acuerdo de las partes, porque fue consensuado, y esa fue la razón por la que hicimos la audiencia en el metaverso, pero con el objetivo que les acabo de explicar, no por jugar, sino porque debemos comprender el funcionamiento del metaverso.
So to conclude a little, the question is, what happened then when a judge needs to sentence something about a legal case that actually occurred in the metaverse? Does the judge know the metaverse? Does he know how it works? It is fundamental to find an agreement to be able to merge these two worlds, and that's why the trial was held in the metaverse.
Voy a compartir un minuto. ¿Cuántos minutos me quedan para ver si alcanzo a compartir algo de la audiencia, por favor, doctor Pedro Luigi?
Me quedan 4 minutos, 3 minutos ahora.
Bueno, muchas gracias. Entonces, en estos 3 minutos voy a simplemente mostrarles cómo funcionaba. Aquí en este caso, nosotros empezamos el proyecto desde enero del año pasado y lo que hicimos fue empezar a mostrar las ventajas del metaverso, también para las reuniones de trabajo, para que las personas pudieran explorar. Y luego hicimos la primera audiencia en el metaverso. Quiero mostrarles solo un poco cómo funciona y este pequeño video de 1 minuto, donde pueden observar, que es lo que me interesa, que aunque parece que fuera una caricatura, los avatars, van a observar que cada una de las partes responde directamente ante las solicitudes que se hacen por parte del tribunal. En este caso, hago la presentación.
Pueden creer que es un poco caricaturesco.
Perdón, allá al fondo se veía la pantalla de televisión donde puede permitirse que no solamente las personas estén conectadas en el metaverso. Y aquí, escuchen.
Cada movimiento que nosotros hacemos es un movimiento voluntario. Por eso, mientras Angie está compartiendo la pantalla, le voy a pedir el favor al señor Ministerio Público que levante su mano derecha. Gracias, doctor. Le voy a pedir al demandado, Policía Nacional, si puede levantar su mano izquierda. Gracias. Le voy a pedir al demandante que, por favor.
Bueno, ya con eso simplemente quería solamente mostrar esto como para poder terminar, y reitero decirles que hay un respeto total y un deseo muy grande desde nuestro país y de todos los jueces por siempre estar a tono con toda la tecnología. La tecnología avanza muy rápido y nosotros a veces nos enfrascamos en unas pequeñas decisiones de automatización y necesitamos tratar al máximo de avanzar. Ese era mi pequeño aporte en este conversatorio. Muchas gracias.
So the last intervention and point was the question, how did it work, this metaverse trial that happened actually in the past January? The trial was held in the metaverse, and behind each avatar that really looks like it's a video game, but it wasn't. Behind each avatar, there was a real person with the legal representative. And then we saw a little demo where actually showed us how the trial was actually held in the metaverse. And Maria wants to conclude, say that she has a lot of respect for the legal world, let's say, and we need to be hanging on technology and his advance, because technology is advancing very quickly and we need to implement it in our life as soon as possible.
Muchas gracias, María Victoria. Creo que esta es la definición más adecuada de pioneering. This is excellent. Thank you very much for your interventions, María Victoria, and we appreciate a lot what you showed us. Bye-bye. So we continue this session now with Frank Paul Flores Garcia, lawyer from Peru, and he will enlighten us with legal interpretation and motivation of judicial decision with artificial intelligence. Please, Frank, 15 minutes, the floor is yours. Thank you for being with us.
¿Cómo están? Buenos días en Perú y buenas tardes para Italia. Hoy les hablo desde la ciudad de Iquitos, que es una ciudad ubicada en el Amazonas peruano y que les invito a conocer. Agradezco la invitación del profesor Luigi Viola para participar en este evento, y también agradeceré el apoyo en la traducción de Ingrid.
You're welcome. So greetings from Peru.
¿Puedo iniciar, Ingrid?
He's very grateful. Sí, greetings from Peru. He's very, Frank is very happy and grateful to have received this invitation, and is thanking each member of the panels, Pierluigi, Luigi Viola, and so forth. He's now starting with his intervention.
Voy a presentar unas diapositivas para dar inicio a la exposición. Y me podría confirmar, Ingrid, sí, me parece que sí, ya se está
se ve
visualizando.
Bien. Sí, se ve bien. Está presentándose.
Vamos a dar inicio. En principio, quiero comentarles que yo actualmente soy un juez peruano especializado en derecho civil. Y en ese ejercicio funcional he dictado una sentencia con asistencia técnica de inteligencia artificial.
So he wants to start by saying that he's a judge and is specialized in civil rights. And recently he has been conducting a trial assisted by artificial intelligence.
Para iniciar la ponencia, considero importante resaltar que el uso de la inteligencia artificial, como de cualquier otra tecnología de la información o cualquier herramienta informática, no es para la justicia una cuestión de moda, ¿no? Sino es un aspecto que busca agregar valor. Valor al sistema de justicia, valor en la predictibilidad y en el tiempo en el que se resuelven los casos.
So he wants to clarify that the use of artificial intelligence nowadays, especially in the legal world, it's not a fashion. It shouldn't be taken as a fashion, but rather as a tool to add some value to the prediction of the cases.
En mi caso particular, dicté una sentencia fijando el monto de una pensión alimenticia con inteligencia artificial, específicamente ChatGPT.
The specific case that the trial he conducted was about the assignment of pensión alimenticia. It's like giving money to the spouse after being divorced. The word escapes me right now. Now we're going to see how he did it. Alimony, I got it, alimony.
La finalidad fue determinar de forma objetiva el porcentaje de la pensión que debía asumir uno de los padres. Anteriormente a esto, era solo una cuestión de criterio jurisdiccional establecer la pensión. No había un margen ciertamente objetivo.
So in this case, what had to be determined was the exact percentage of the money to be paid in this alimony by one of the parents, and the assignment of this percentage needed to be done exactly.
Mi actuación fue como juez de segunda instancia, y la decisión de usar inteligencia artificial se motivó en un argumento común de los impugnantes, que era que no se conocían la forma de cálculo en la que se establece el porcentaje de la pensión.
So the decision to use the artificial intelligence in these cases was due to the fact that they didn't know how to calculate this particular case, the percentage of money to be paid by the parents.
En Perú se reconoce la obligación alimentaria común de ambos padres, y para fijar la pensión se debe conocer la información económica integral de ambos y además los gastos de manutención del niño. ChatGPT nos asistió en hacer la operación de cálculo de proporcionalidad para determinar el porcentaje. El juez de primera instancia determinó 20% y con ChatGPT resultó 21.34%, aproximado a lo que se venía impugnando. La sentencia fue confirmada.
So the decision to use this artificial intelligence, in this case was actually ChatGPT, was because it wasn't clear how to implement this calculation. And the situation is that both parents should provide an alimony, provide child support, depending on different situations like the economic situation of each of them, and what kind of actually cost would determine for the requirements would be necessary for the child. And they used ChatGPT to determine the exact percentage. And a first trial was determined at 20%, but by using ChatGPT in a second instance was determined that the percentage should have been 21.34%.
Para mí es importante siempre resaltar que el uso de la inteligencia artificial no significa un reemplazo o una sustitución de la decisión humana. La inteligencia artificial es una herramienta de auxilio porque finalmente, por más sencillo que sea el caso, la decisión siempre debe ser revisada, verificada y aprobada por el juez.
So he wants to really stress the fact that the use of artificial intelligence should not replace the human intervention and final word. It should be seen as a tool, a simple tool that is supposed to help, support the decision, where actually in the final instance should be approved and reviewed by a human being.
La sentencia se dictó en marzo del 2023 y en julio del 2023 en Perú se dictó la ley 31.814 que promueve el uso de la inteligencia artificial a favor del desarrollo económico del país. Esta ley señala que es de interés nacional el fomento del desarrollo y uso de la inteligencia artificial para la mejora de los servicios públicos y especialmente para la administración de justicia. Con esta ley, los jueces peruanos podemos aplicar inteligencia artificial en nuestras decisiones.
So this trial was held in March 2023, and already in July 2023, there was a law which was promoted that saw the artificial intelligence being applied by law in several legal cases, and that should be seen as a national interest that moves to an improvement of the public services where the judges can be actually helped.
En septiembre del 2023 hubo una reforma constitucional. No se puede usar tecnología de la información sin Internet. Entonces, a través de esta reforma constitucional, se reguló como derecho fundamental de los peruanos el acceso libre al Internet y también el uso de las tecnologías de la información.
In September 2023, there was a constitutional reform that regulated the access to Internet precisely to move on in the implementation of the artificial intelligence.
A partir de octubre del 2023, para el Poder Judicial existe un reglamento interno que regula el uso de la inteligencia artificial para casos específicos, especialmente aquellos casos sencillos o de menor cuantía.
In October 2023, there was a new internal regulation that was aiming at precisely regulating the use of artificial intelligence, especially for those specific cases that weren't too huge or important or complicated.
Mi tema es cómo usar la inteligencia artificial para interpretar normas y para motivar decisiones judiciales. Aquí dos ejemplos. Nosotros tenemos, como en Italia, los precedentes vinculantes. Tenemos una interpretación confusa respecto de una norma sobre el poseedor precario. En Perú tenemos dos tipos de desalojos, el desalojo contra el precario y el desalojo contra el arrendatario o inquilino.
So what we're seeing here is that the question is how to use artificial intelligence or ChatGPT to interpret, to give an interpretation to cases. Here we're talking about precedents in the sense of preceding cases that can constitute a legal base to decide also for future cases. And that's what we're seeing right now in the slide.
Discúlpeme, Judge
La
Flores,
diferencia.
recuerdo que perdóneme, tiene 2 minutos para acabar. Tenemos que ser muy estrictos.
Sí,
lo siento mucho.
Vamos terminando.
Muchas gracias.
La diferencia entre el desalojo contra el poseedor precario y el desalojo contra el arrendatario es la competencia judicial. En el caso del inquilino lo conoce un juez de menor cuantía y en el caso del precario lo conoce un juez especializado. La interpretación aceptada es que el vencimiento del contrato de arrendamiento no afecta el título. Entonces, la competencia original se mantiene. Esa interpretación se corresponde con aquella que podemos obtener también a través de ChatGPT.
So basically, what I understand from this last slide, we're talking about who is competent, who is responsible, who is eligible for a case of rentals disputes. And here the use of ChatGPT or artificial intelligence in general could really help.
Finalmente, con el uso de la inteligencia artificial, podemos lograr que las decisiones judiciales estén en texto sencillo y sean entendibles por cualquier ciudadano. Con eso evitamos sentencias muy extendidas en textos e incomprensible para los ciudadanos que no son abogados. Lo que se promueve es el uso de un lenguaje sencillo. Eso es todo de mi parte. Muchas gracias.
Finally, the use of artificial intelligence has the purpose to take decisions that results in sentences that have a very easy to read text and even a little shorter that can be more understandable by the users who are not lawyers.
Le agradecemos mucho su ponencia, Judge Flores García. Muy interesante. Comentaré al final en las conclusiones también esas decisiones pioneras. Y I will switch to English now. I thank Judge Flores Garcia for this wonderful presentation and this pioneering use of ChatGPT, especially in making decisions. We will move to next presenter, José Osvaldo Ledesma, that will talk us about ChatGPT as a tool for easy reading of judicial resolutions. Please, Osvaldo, the floor is yours.
Muchas gracias por la participación. Thank you very much.
Buenos días, buenas tardes. Bueno, antes que nada quiero agradecer a Pierluigi Casale y a Luigi Viola la invitación, a Ingrid la gentileza de traducirme al inglés y a Gerald García Báez, mi amigo mexicano, sin cuya intermediación no tendría el honor inmerecido de estar aquí compartiendo con ustedes algunas ideas sobre el lenguaje claro y la lectura fácil en las resoluciones judiciales.
So first of all, he wants to greet us and thank for this wonderful opportunity, especially the hosts and the organizers of this panel.
Bien, voy a compartir una pantalla con ustedes. Perdón, no puedo compartir. Creo que es problema de de mi laptop.
¿Puedes hacer?
Bueno, sí, de todas formas, lo voy a exponer así directamente. Hace casi 9 años soy juez en una localidad muy pequeña, acá en Argentina, en el nordeste de Argentina, y una de las cosas que me llamó la atención desde un primer momento fue cómo hacer para tener una comunicación más efectiva y más comprensible hacia el ciudadano, dado que nosotros acá en la justicia de paz tenemos determinados procesos que pueden tramitar sin patrocinio letrado, es decir, sin un abogado que haga de traductor del lenguaje jurídico al lenguaje que utiliza el ciudadano que no está versado en derecho.
The aim of this talk is talk about how to get an easier reading of the legal text using artificial intelligence. Jose is a judge in a small town in Argentina, and he's always been interested in the doubt in how communicating in an easier way and faster way with the citizen or their clients without the intervention or the translation done by other lawyers.
Bien, y tenemos en materia de lenguaje claro una distinción entre lo que es lenguaje claro propiamente dicho y lectura fácil. El lenguaje claro propiamente dicho es aquel que está destinado a personas de instrucción media, es decir, personas que no tienen un entrenamiento, no están versadas en el ámbito jurídico o en el ámbito judicial, pero sí tienen un nivel de instrucción que les permite entender si se utiliza un texto que no esté, digamos, adornado con latinismos, aforismos, barbarismos, arcaísmos, etc. Mientras que la lectura fácil es aquella que está dirigida a personas con una escasa o nula instrucción, pensemos personas analfabetas, o bien con algún tipo de dificultad cognitiva. En consecuencia, la lectura fácil tiene que ser mucho más simplificada de lo que es el lenguaje claro propiamente dicho.
So we have two readings we need to take into consideration. One, it's what is called a clear language, and the other one is called an easy reading. A clear language means that the document maybe can be written without all the technical terminologies, and the user, which in this case it's a citizen with a mid kind of level of education, can still understand. There is no lawyer needed, and there are no they're not like present in the document terminology which is too technical, and in this case the citizen can still read it. And then the other one, which would be an easy reading, would be aiming at the final user, which in this case would be a citizen which has very little instruction. We can also call it an alphabet, and in this case we need to make the text and the resolution very accessible without any of the terminology and even paraphrases.
Desde el punto de vista de la estructura de la resolución judicial, el lenguaje claro se aplica a la totalidad de la resolución, mientras que la lectura fácil únicamente en un apartado o en un considerando o en un párrafo especial con letras con un tamaño mayor, con resaltadas con negrita, con algún tipo de atractivo visual para que esa persona pueda enfocar su lectura y pueda hacerle mucho más comprensible a esa persona que tiene alguna dificultad especial para poder leer la totalidad de la sentencia y por lo menos tener una noción de qué se trata.
So the clear language, it's a strategy that needs to be implemented in the in the integrity of the document, meaning all the documents should be written, it will be written in this clear language. Whereas the easy reading, it's usually implemented in just a little part of the text, maybe a paragraph where there is like a summary of the disposition, and it needs to be visually clear, maybe using another font or maybe using a different type of visual attractive system so that the reader can easily understand in summary what's going on.
Bien, ¿y cómo entra a jugar ChatGPT en esto de la simplificación del lenguaje, ya sea tanto en lenguaje claro como lectura fácil para personas en situación de vulnerabilidad. Bueno, el uso que se le da es un uso analítico. En realidad, cualquier inteligencia artificial puede servir para esto. Yo particularmente trabajé para esta exposición en ChatGPT, pero puede servir en GoogleGemini, puede servir en Bing Copilot y cualquier otra similar. Uso analítico, ¿qué quiere decir esto? Que yo le voy a suministrar un material y le voy a pedir a través de un prompt o una instrucción que procese y que me arroje una respuesta a raíz de ese material que yo le suministro. En este caso, una resolución judicial. A diferencia de los usos creativos en los cuales yo incorporo un prompt y la inteligencia artificial se encarga de generar todo el contenido sin que yo le proporcione anteriormente un material específico.
Okay, so how can we use GPT for this purpose? We need to clarify the fact that in this specific case, ChatGPT was used, but however, any artificial intelligence system could actually do it. There was an analytic use and a creative use. An analytic use means that the artificial intelligence tool has been instructed with clear instructions and material to generate a final, let's say, text in this case. And a creative use, it's when we do instruct the artificial intelligence tool, but however, we don't provide any material.
¿Qué requiere el uso del ChatGPT en esta tarea de simplificar el lenguaje? Bueno, en primer lugar, prompts útiles. Hay que tratar de utilizar prompts que contengan la mayor cantidad de información y de contexto para que la inteligencia artificial generativa sea capaz de interpretar qué es lo que realmente nosotros queremos. Pero sobre esto no hay una receta única, sino que es un poco ensayo y error, es decir, hay que ir probando diferentes. Yo tengo una receta en particular, pero no quiere decir que sea una verdad revelada. Otra cosa, preservación de datos y seguridad, los datos de las personas. Antes de introducir información sobre personas, hay que pasarlo a iniciales o bien seudónimos para preservar los datos de estas personas y la seguridad también, preservar la seguridad de los sistemas. Conocer el tema y conocer la causa. Si no conozco el tema a nivel teórico o jurisprudencial, o tampoco la causa, es decir, no me leí el caso, no voy a poder revisar y controlar que el resultado que me arroja la inteligencia artificial generativa sea realmente lo que yo, digamos, se ajuste realmente a lo que corresponde, es decir, que no haya las llamadas alucinaciones que provoca este tipo de tecnología. Y por último, el toque personal. Siempre es posible darle un valor agregado propio del ser humano al resultado que arroja la inteligencia artificial. Yo creo que es un poco, en eso radica la importancia de utilizar estos sistemas como un asistente o un complemento y no un reemplazo de la persona humana, en este caso del juez.
So what is needed here? What do we need to actually feed an artificial intelligence tool to provide us with the relevant information? First of all, we need to use prompt, and this prompt should be useful and clear with a lot of information and context. Second, we need to accept the fact that there's going to be a trial and error path. So there might be some error, but we need to keep on changing and trying accordingly. And there is no single useful recipe. Maybe he has his own way of doing things, but we need to adapt it to each situation. Fourthly, the information about people, we should be careful and provide pseudonyms because it's, the identity of people should be protected. And then we need to know the topic very well, at least the theory. Otherwise, it's not possible to review the final result. And finally, we need a personal touch.
Bien. Desde el lenguaje claro, el ChatGPT o GPT puede ayudar a mejorar el texto en 3 niveles del análisis lingüístico. El nivel léxico, es decir, el de las palabras, el vocabulario de un idioma. El nivel morfosintáctico, que tiene que ver con cómo la estructura interna de las palabras y cómo se relacionan entre sí, y las distintas palabras para construir unidades gramaticales mayores como enunciados, frases, oraciones. Y el nivel discursivo, es decir, el nivel macro del texto en su totalidad, nos puede ayudar, por ejemplo, a mantener el hilo argumental, evitar reiteraciones, evitar contradicciones lógicas. Bueno, sobre esto no me voy a explayar porque quiero ir directamente, me queda poco tiempo, a el nivel, a la lectura fácil, perdón. Yo para la lectura fácil utilizo un prompt donde les suministro la siguiente información. En realidad son dos prompts encadenados. Un primer prompt donde le pregunto qué, cómo, cuánto y para quién. Y un segundo prompt donde hago el ajuste del tono. Porque la primera respuesta me la da en forma muy despersonalizada, muy fría. Y en este tipo de simplificación del lenguaje, en la lectura fácil, yo necesito una cercanía entre el juez y la persona destinataria de ese texto.
So first of all, it has to be mentioned that how GPT can improve the text. There are 3 levels: lexical, morphosyntactical, and discursive, meaning that it's a way also to avoid contradictions. And we fast forward into the easy reading. How does he use his prompts? First of all, he uses prompts defining the what, how, when, and why, and then is gonna use another prompt to adjust the proper tone.
Bien, bueno, el ejemplo yo utilicé, acá ustedes no pueden ver mi pantalla, en todo caso puedo compartir después con los organizadores la presentación, un caso de adopción de integración de un niño. Entonces, lo que yo le pedí a través del primer prompt al ChatGPT fue: resume esta resolución judicial, entre comillas, utiliza lenguaje fácil y una extensión máxima de 100 palabras para que lo entienda un niño de 10 años. En el segundo prompt le pedí que hiciera lo mismo, pero en primera persona, como si tú fueras el juez y debes dirigirte al niño. La respuesta que arrojó el ChatGPT es: hola, quiero explicarte algo importante sobre una decisión que debo tomar. Hay una familia que quiere formalizar su relación con un niño muy especial como tú. La adopción es cuando una familia te cuida y te quiere mucho, se convierte oficialmente en tu familia. En este caso, aunque el hombre que quiere ser tu papá no vive contigo y tu mamá, ustedes siguen siendo una familia unida. Mi trabajo es asegurarme que tomo la mejor decisión para ti. Creo que es importante que seas oficialmente parte de esa familia que te ama tanto y que puedas llevar su apellido si así lo deseas.
So the prompt that he used in a specific case was a case about an adoption of a child, and it was essential to produce a document in an easy language. First of all, a language that could be read to or by the child itself, but also another part of the text that was aimed to go to the actual judge, so how the judge was supposed to read this text. And basically what the text was, what the artificial intelligence produced was a text where he was explaining that, hey, there is a family that want to adopt you. You always be part of the original family, although you're not living together. I'm trying to, my goal here is trying to find the best solution for your interests.
Perdónenme, José Osvaldo, le ruego amablemente de hacer las conclusiones.
Bien, perfecto. Bueno, la inteligencia artificial generativa, siendo que los abogados en general y los jueces en particular trabajamos con la palabra, puede ser de gran ayuda a la hora de redactar estos textos escritos. Todo lo que hace la inteligencia artificial generativa lo puede hacer claramente el abogado o el juez. Pero la idea es justamente utilizar estas herramientas para potenciar nuestro trabajo, para hacerlo más eficiente y para poder hacer del servicio de justicia algo más accesible a su verdadero destinatario, que es la persona que solicita el servicio de justicia. Y para finalizar quisiera terminar con una frase de Richard Susskind, quien hace más de una década dijo: en el futuro la mayoría de los abogados no serán ni litigantes ni asesores, sino ingenieros legales. Tenemos que poner la tecnología a nuestro lado, porque el mundo ya lo hace. Como dijo Victoria recién, no dar la espalda a la tecnología y ponerla, como dice Richard, a nuestro lado. Yo creo que es importante, y no solo para estar al frente, sino para no quedarnos atrás. Muchas gracias y buenas tardes.
So the final point that he's making is that the artificial intelligence, in the end, in this case, needed to work with words. That's what lawyers do anyway. They work using words. And the artificial intelligence is supposed to help with this text that are produced, and to use it, and so to make the work a little bit more efficient, especially for the final user, which is a citizen. He concludes with a quote: "The future of the lawyer," that goes more or less like, in the future, the lawyers won't be lawyers, will be actually legal engineers.
Muchas gracias, José Osvaldo. Thank you very much, José Osvaldo. Let's move on. I will comment at the end. And after listening how magistrate judges are starting using artificial intelligence, let's have the point of view from lawyers. I will introduce Elena Bassoli, that she will speak in English, so that will help us understand also the way that lawyers see artificial intelligence, machine learning, and actually what's their thoughts on it. Please, Elena, the floor is yours.
Thank you. Good afternoon, everybody. And first of all, I thank the organizers for the invitation. My speech will concern the 5 fundamental principles of the European Ethical Charter on the use of artificial intelligence in judicial systems and their environment. This is the first European instrument to set out 5 substantial and methodological principles that apply to the automating processing of judicial decisions in data based on AI techniques. Developed by the Council of Europe's European Commission for the Efficiency of Justice, it is aimed at private companies like startups active on the market of new technologies applied to the legal service or legal techs, public actors in charge of designing and deploying AI tools and services in this field, public decision makers in charge of the legislative or regulatory framework and the development, audit, or use of such tools and services, as well as legal professionals. And here are the 5 principles. Take a moment and just need a moment for share with you the slide. Sorry, slide. Not a document. Here it is. And here are the 5 principles of the Ethical Charter on the use of artificial intelligence in judicial systems and their environment. The first principle is the first respect for fundamental rights. Ensure that the design and implementation of artificial intelligence tools and services are compatible with fundamental rights. The second principle of no discrimination, specifically prevent the development or intensification of any discrimination between individuals or groups of individuals. The third principle of quality and security is with regard to the processing of judicial decisions and data. Use certified sources and intangible data with models elaborated in a multidisciplinary manner. in a secure technological environment. The fourth principle of transparency, impartiality, and fairness make data processing method accessible and understandable, authorize external audits. 5. Principle under use control. This principle precludes a prescriptive approach and ensure that users are informed actors and in control of the choices made. But let's take a look at the details of these 5 principles. The first, respect for fundamental rights, says that the processing of judicial decisions and data must serve clear purposes in full compliance with the fundamental rights guaranteed by the European Convention on Human Rights and the Convention on the Protection of Personal Data. When artificial intelligence tools are used to resolve a dispute or as a tool to assist in judicial decision-making or to give guidance to the public, it is essential to ensure that they do not undermine the guarantees of the right of access to the judge and the right to a fair trial, for instance, equality of arms and respect for the adversarial process. They should also be used with due respect for the principles of the rules of law and judges' independence in their decision-making process. Preference should therefore be given to ethical by design or human rights by design approaches. This means that right from the design and learning phases, rules prohibiting direct or indirect violations of the fundamental values protected by the conventions are fully integrated. The second principle of non-discrimination. Given the ability of these processing methods to reveal existing discrimination through grouping or classifying data relating to individuals or groups of individuals, public and private stakeholders must ensure that the methods do not reproduce or aggravate such discrimination and that they do not lead to deterministic analysis or uses. Particular care must be taken in both the development and deployment phases, especially when the processing is directly or indirectly based on sensitive data. This could include supposed racial or ethnic origin, socioeconomic background, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health-related data, or data concerning sexual life or sexual orientation. When such discrimination has been identified, consideration must be given to corrective measures to limit or, if possible, neutralize these risks and also to raise awareness among stakeholders. However, the use of machine learning and multidisciplinary scientific analysis to contrast such discrimination should be encouraged. The third principle of quality and security says that designers of machine learning models should be able to draw widely on the expertise of the relevant justice system professionals, like judges, prosecutors, lawyers, etc., and researchers, lecturers in the field of law and social science, for example, economists, sociologists, and philosophers. Forming mixed project teams in short design cycles to produce functional models is one of the organizational methods making it possible to capitalize on this multidisciplinary approach. Existing ethical safeguards should be constantly shared by these project teams and enhanced using feedback. Data based on judicial decisions that is entered into a software which implements a machine learning algorithm should come from certified sources and should not be modified until they have actually been used by the learning mechanism. The whole process must therefore be traceable to ensure that no modification has occurred to alter the content or meaning of the decision being processed. The models and algorithms created must also be able to be stored and executed in secure environments so as to ensure system integrity and intangibility. The principle of transparency, impartiality, and fairness. A balance must be struck between the intellectual property of certain processing methods and the need for transparency, access to design process, impartiality, absence of bias, fairness, and intellectual integrity, prioritizing the interests of justice. When tools are used that may have legal consequences or may significantly affect people's lives. It should be made clear that these measures apply to the whole design and operating chain as the selection process and the quality and organization of data directly influence the learning phase. The first option is complete technical transparency, for example, open source code and documentation, which is sometimes restricted by the protection of trade secrets. The system could also be explained in clear and familiar language to describe how results are produced by communicating, for example, the nature of the services offered, the tools that have been developed, performance, and the risks of error. Independent authorities or experts could be tasked with certifying and auditing processing methods or providing advice beforehand. Public authorities could grant certification to be regularly reviewed. And finally, the fifth principle, under user control. User autonomy must be increased and not restricted through the use of artificial intelligence tools and services. In particular, the judge should be able to return at any time to the judicial decisions and data that have been used to produce a result and continue to have the possibility of departing from it, taking into account the specificities of the case in question. The user must be informed in clear and understandable language whether or not the solutions offered by the artificial intelligence tools are binding, of the different options available, and that he has the right to legal advice and the right to access a court. He must also be clearly informed of any prior processing of a case by artificial intelligence before or during a judicial process and have the right to object so that his case can be heard directly by a court within the meaning of Article 6 of the European Convention on Human Rights. Generally speaking, when any artificial intelligence-based information system is implemented, there should be computer literacy programs for users and debates involving professionals from the justice system. And finally, in my opinion, these include principles such as the primacy of law. The effect of these tools may be not only to provide incentives, but to be almost prescriptive, creating a new form of normativity, which could supplement the law by regulating the sovereign discretion of the judge and potentially leading in the long term to a standardization of judicial decisions based no longer on case-by-case reasoning by the courts, but on a pure statistical calculation linked to the average compensation previously awarded by other courts. This is actually the main risk I see in the near future. I thank you for your attention.
Thank you very much, Ms. Basori. And this is very important for the ethical perspective of using technology, in particular artificial intelligence. This would be my time for conclusion, but actually we have here to the stage Ryan Abbott, that was mentioned before, from Gerald Garcia. He is the lawyer that is bringing several of the cases of copyright for artificial intelligence. I would really like to listen from him. What is going on and what's happening? Ryan is connecting from Los Angeles very early in the morning. Thanks, Ryan, for being here. We have strict times, but we still have 10 minutes to listen. Please go ahead, and hopefully in 10 minutes we can grasp what's your message. Thank you very much, Ryan.
Oh, my pleasure. I'm very sorry to cut into your conclusion, but can everyone hear me okay?
Wonderful.
Great. Well, I'm trying to upload some slides here, but we may just have to do it without slides.
You can share your screen, and I will allow you.
Yeah. Stop cam. It says present, and it has slides uploading. I don't see a show screen button. Share screen. There we go. Okay.
Right. Wonderful. Here you are.
Well, that would require my computer to give new permissions and then reset and start back up. So I'm not sure we should do that. Oh, but you can see those slides.
Yes.
So that's through slide sharing. All right, good enough. Anyway, so I'm here to talk about some lawsuits that we filed that I think are kind of interesting. And with 10 minutes, we're going to do it real quick. These lawsuits basically concern whether or not you can protect AI-generated output with certain sorts of intellectual property rights. You know, the first being copyright, although we're perhaps better known for the patent cases. But there was a lot of academic discussion about this really for a long time because it was a theoretically very interesting question, but really no law at all, except a few laws. So the United Kingdom in 1988 changed their Copyright Act to say that if you have an AI-generated work, which they define as a work that lacks a traditional human author, that the work gets protection. It gets protection for a shortened period, 50 years from the date of creation, as opposed to 70 years from the life of an author. And the producer of the work, the person who undertakes to have the work created, is deemed or fictionalized to be the author. And this was done because in the 80s, the British Computer Society thought that you'd have widespread confusion in the creative industry if we didn't have clear rules. Well, it turned out to be 35 years ahead of its time, but here we are now with widespread confusion in the creative industry about whether, if you're using GPT or Gemini or Midjourney, and it makes something creative and valuable, whether you can own that sort of thing. The United States has gone the other direction. Since 1973, actually, they had a Copyright Office policy, though it was hard to find, that said if you had something made without a traditional human author, you couldn't have a copyright on it. And they cite to this very old case involving this picture of Oscar Wilde in support of that policy, and basically said copyright is designed to promote the fruits of, you know, creativity and the mind and the intellect, and AI doesn't have those things, and therefore there's no need for protection. And so there had really never been a case on this. There was one case involving a picture taken of a monkey that ended up getting dismissed, but dismissed on the basis that monkeys aren't allowed to bring lawsuits in the United States. And other than that, there had really been no case. And no one really cared about it too much until, again, very recently, with the availability of large language models. This is a piece of artwork that won a state art fair in America and was made using Midjourney. And the Copyright Office registered a copyright in it to the human author, the human artist. And when they found that he had used Midjourney from statements he made in social media, they canceled the registration. And so, again, there is now really very active commercial interest in owning this sorts of output. Right now, the Copyright Office's position has been, again, though, that Copyright Office only protects human creativity, and therefore you can't get protection. So this is a piece of art made by an AI system owned by a computer scientist named Stephen Thaler, whom I represent. And this work was submitted for registration to the Copyright Office in 2018, and they rejected it as being AI generated. And of course, you can't have an AI own a copyright because it's not a legal person and it wouldn't make a lot of sense. But there's plenty of reasons for people to own artwork made by AI systems. The US Supreme Court has said that in America, copyright exists to promote the generation and dissemination of works. And so if we want more creative works, then encouraging people to make and build AI systems that generate creative works and encouraging people to use those systems are going to achieve the goals of copyright law. And if we say, well, if a generative AI touches the creative process, there's no more protection, that's a real disincentive to using AI in the creative industry. And in fact, in the US, copyright law allows corporations to be authors, and there is no requirement to disclose any sort of human contribution to a work whatsoever. So we filed this case in the District of Columbia District Court, which ruled against us. It is now before the District of Columbia Appellate Court, and we have recently filed our opening brief. So we will see what the District of Columbia Appellate Court says, but it is the first case in the United States to argue this. And if it rules against us, Congress has already started debating whether or not they want to amend copyright law. Of course, different jurisdictions have different goals of copyright. France, for example, has it primarily to protect the moral rights of human authors. So not every jurisdiction may want a system that promotes the generation and dissemination of works, but these are very much kind of topical issues around the world, as are a dozen lawsuits that have been filed about whether it's infringement to train machine learning systems based on someone else's protected work, along with a whole other group of causes of action based on generative AI allegedly infringing in some way some IP right. We also filed a series of test cases on patent law. So this green thing is something that is a car suspension, and the silver thing is a car suspension made by a team at Siemens. And Siemens was unable to file for a patent on the silver car suspension because the inventors, the human inventors, said that the AI invented it and that they hadn't really done anything inventive, that the problems to be solved were well known, the output was obviously valuable, they had an AI that optimized industrial components, they weren't willing to say they were inventors, and as a result, you couldn't get a patent. Well, similar to the copyright theory, that's not a good outcome. If patent law exists because we want to promote innovation, commercialization of new inventions, and disclosure of confidential information or trade secrets, then we want that system to function regardless of how inventions are made. We want to encourage people to make and use inventive AI to help find new drugs or make better car parts or make you name it. And right now, it's not clear the patent system is going to do that. So there was even less law on the patent front about what to do with an AI-generated invention than there was with an AI-generated work. So we had an AI make two inventions. One's called the fractal container. It's this beverage container shown here. We had 3D printed. Again, a machine predicted this would be easy to grip and that it would increase surface area, so improve heat transfer. It was, in fact, very easy to grip, although very difficult to drink out of and impossible to clean. But it is just an invention, not an actual commercial product. And so we filed this now in 17 jurisdictions and said, well, this was invented by an AI, and the person who owns it is the owner of the AI. And we had a patent issued in South Africa and should soon have one issued in Saudi Arabia. A first level federal court in Australia held that under the Australian Patent Act, an AI could be an inventor and that the person who owned the AI system would own the invention. That decision was overturned on appeal. The European Legal Board of Appeal ruled that you cannot have an AI listed as an inventor, but that there's no particular requirement for inventorship in European law And as a result, the user or the owner of the AI can be listed as an inventor, and the specification can even state that an invention is AI generated. So we refiled the applications, are waiting on decisions on that. In Germany, 2 federal appellate courts have split on this and sent it to their Supreme Court. Last December, the UK Supreme Court ruled on this and said, you can't protect an AI-generated work, although it didn't give the level of contribution that a person or a machine would do. But if you didn't have a human being who had been a deviser of the invention, you simply couldn't get a patent. So that was the UK Supreme Court approach. And the US Supreme Federal Circuit said something similar and basically said, if you don't have a traditional human inventor, you can't get a patent. As a result of that, a couple of weeks ago, the US Patent and Trademark Office put out a new guidance basically saying what a human being had to do to get a patent on an application. And it is more than simply prompting a generative AI or relying on a generative AI to do most of the work. So this is important in the United States, where if you have the wrong inventorship, you can invalidate a patent in litigation. And so we are likely to see, as a new defense to patent infringement, you don't have human inventorship in your patent or accurate inventorship. Really, a lot of work was done by a generative AI. But of course, again, this isn't a good system if we don't really care how something was made. We just want to promote innovation. And this is going to be a particular challenge as AI gets better and better at making creative works and inventive contributions, and human beings don't. So that was 10 minutes, and I will stop there.
Thank you very much, Ryan. We were really looking forward to hear from you this advancement and this challenge that we are seeing. I would like to thank you, all the speakers, all these pioneers in this field that is still open, still uncertain. I took some notes that I will make available and in a separate short video after the conference. And because I think it's my pleasure now to introduce the keynote speaker of this session, Professor Martin Ebers. Professor Martin Ebers is a distinguished figure at the intersection between law and technology, and I follow him since many years, actually. Professor Ebers is the president of the Robotic and AI Law Society in Germany. He is a professor of IT law at the University of Tartu in Estonia, which I think she's now in Estonia, or she's going to Estonia. Well, we will see. Dr. Ebers leads background research project, including project exploring private rule making and European governance of AI and robotics. This afternoon, Professor Ebers will help us understanding a bit better the regulation upcoming in Europe, the AI Act, and hopefully its implication in the legal sector. Please, Professor Ebers, thanks to be with us. The floor is yours.
Yeah, thank you so much for this warm welcome. Indeed, greetings from Estonia, or more specifically from Tallinn. That's actually where I am right now. But after my talk, I have to head directly to the airport. So I also have to stick to the time, which is, of course, a little bit challenging, given that the AI Act, where recently a political compromise was reached, actually has a lot of things we could discuss, and of course also consequences for the legal sector. So now I would like to share my screen. I hope it's possible. I have to see where.
You can go to present, share screen, and I will allow you on the floor.
Present and slides or video? No, share screen, right?
Share screen.
Yes, I did this already. Allow streamer to see your screen. Okay, I have to allow this, but I cannot do this. No. Share screen. Okay. Select screen. Okay, here we go. Just a second. So Now you should see my screen, hopefully.
Yes.
Okay, wonderful. So where are we right now? Well, there is almost a final text available right now, but still the final version will be most likely available in April. So I think the numbering will still change. It looks right now quite chaotic, and also language-wise, only the English language version is available and the others are not. Well, when we talk about the AI Act, then we have to take into account that the AI Act is not the only piece of regulation. Basically, the AI Act is based on the overall design of product safety law. The main goal of the AI Act is to make sure that AI systems, before they are released on the market, are safe enough and do not pose significant risks to health, to safety, but also to fundamental rights. But there's also other product safety regulation in place. Two recently adopted regulations, the General Product Safety Regulation and also the Machinery Safety Regulation. And then regarding specific products, we have a lot of other EU acts here that also regulate, like product safety law, and there's some overlap with the AI Act. And then once an AI system is on the market, still things can happen, and it might be that an AI system causes a damage, and therefore we will have also, together with the AI Act, a new product liability directive. The old product liability directive is of 1985, and with a view to new technologies, it was necessary to adopt here a new product liability directive. So this will be also adopted under the current European Parliament and under the current European Commission. The other proposal, the AI liability directive, though, will not be adopted in this term due to various reasons. So now let's have a closer look at the AI Act. I will especially deal with high-risk AI systems, but before doing so, I would like to give you a short overview. So as you all might be aware, the definition of AI is one of the most contentious issues, and actually until the final agreement was reached, was still very much in progress. So what is now the definition of an AI system? Article 3 follows basically the OECD definition, according to which an AI system is a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment. So these are basically the two elements, varying levels of autonomy, and that there may be some kind of adaptiveness. Now, the problem with this definition is that the AI Act does not tell us the threshold of automation from which on we can say this is an AI system. So it just refers to varying levels of autonomy. And also regarding the adaptiveness of the system after deployment, the text just says it may exhibit adaptiveness. The recitals are a little bit more revealing because the recitals say that the definition should not cover systems that are based on rules defined solely by natural persons to automatically execute operations. On the other hand, the definition is still broad because the recitals also refer not only to machine learning approaches, but also to logic and knowledge-based approaches that infer from encoded knowledge or symbolic representation. The only kind of systems that are out of the scope is then basic data processing, and this in itself, I think, is still then a very broad definition. So you can say basically a lot of software systems fall under the definition of an AI Act. Now, who is actually covered by the AI Act? Well, for one, providers that place the products on the market or puts the system into service, but also deployers that are basically those that use an AI system under their authority. There can be both private entities, but also public authorities, and even third country providers and deployers are covered where the output produced by the system is used in the European Union. Then I think we are all aware of this risk-based approach, according to which the higher the risk, the stricter the rules. So we have one article, Article 5, that regulates AI systems that are prohibited because they actually have an unacceptable risk. Then most of the AI Act is about high-risk AI systems. They are permitted, but before they can be released, they are subject to mandatory requirements and this ex-ante conformity assessment. Then we have AI systems that are subject to transparency obligations, and then we have those that have no or minimal risks. Now, this was actually the idea of the European Commission before generative AI came into play and ChatGPT was released. And therefore, so to say, in the last minute, there were introduced also rules on so-called general purpose AI systems, so GEPI. This is a little bit against the risk-based approach, basically for two reasons. One reason is the AI Act actually originally did not intend to regulate a certain technology, but of course the provisions on GEPI are pretty much about a certain technology. And second, the AI Act was about the concrete risks of concrete use cases, whereas the provisions actually regarding GEPI are not about a concrete use, because at the moment where generative AI is being developed, it is simply unclear for what use they will be used later. So then what is basically the timeline where the AI Act still has to be published in the official journal? After that, already 6 months later, the rules on prohibited practice are enforceable. 12 months later, then the rules on general purpose AI systems come into force. 24 months later, then the Annex 3 high-risk AI systems provisions and the transparency obligations are applicable, and 36 months then for the Annex 2 high-risk AI systems. The AI Act itself leaves a lot of questions open. So therefore, it remains to be seen how this act, how this regulation will be implemented. And this depends pretty much on the European Commission, because the European Commission will issue guidelines on the interpretation of the AI Act, how, for example, to understand the definition of AI, but also many other aspects of the AI Act will be interpreted by the means of guidelines by the European Commission. The European Commission has also the power to adopt implementing and delegated acts. And especially in the field of GEPI systems or models, the European Commission will approve a code of practice. And last but not least, also the European standardization organizations, CEN and CENELEC, are right now developing standards which once when they are published in the official journal of the European Union, become harmonized standards, and providers following these harmonized standards then can enjoy the so-called presumption of conformity. So if they can show that they followed these harmonized standards, then there is the presumption that their AI system is in conformity with the system. Now, what is the problem? The problem is all these rules enter into force already 6 months, 12 months, up to 36 months into force, whereas the guidelines, the implementing delegated acts, and all of that have no clear timeline. So that might cause a lot of insecurity. Now, I would like to point out especially here the following. Now, when we look especially at the judicial system, then Annex 3 comes into play, and especially the last point. The administration of justice and the democratic process is an area that is regarded as a high-risk area. So if you use an AI system there, if a judicial authority uses an AI system there, it qualifies as an AI system. But there is also a so-called additional layer that was introduced also during the negotiations. And this additional layer makes it possible that even if a system qualifies as high risk, then the provider has the possibility to say, well, this still does not qualify as a high-risk AI system. Because if the AI system does not pose a significant risk of harm to health, safety, or fundamental rights of natural persons, then actually then the provider has to document this assessment. The national authority has access to this documentation on request, and the provider has to register the AI system in the EU database. But the bottom line is that then the AI provider does not have to follow the rules of the AI Act regarding high risks AI systems. I can see that my time is already over. If you would still give me 2 more minutes, there's a lot of obligations of providers. There's lots of obligations also of deployers of high-risk AI systems. For instance, deployers also have to control the input data and make sure that the input data is relevant. They have to monitor the operation of the AI system, and even it is necessary to carry out a fundamental rights impact assessment if this is a body governed by public law, and that is of course the case if it is a judicial authority. But judicial authorities using a certain system, for example, ChatGPT, under certain conditions can be even regarded not only as deployers, but even as providers, because according to the AI Act, if they modify the intended purpose of an AI system, including a non-high-risk JEPI, then they qualify as providers of AI systems. Let me conclude. I think by and large, the AI Act is a good piece of legislation, but it has some flaws. For example, the coherence is not there. The AI Act will overlap, interfere, and also contradict with existing EU laws. Then the AI Act does not really follow a true risk-based approach. There's lots of compliance costs and regulatory burdens, especially for small and medium-sized enterprises. There's also lack of safe harbors, and there's a lot of legal uncertainty until the European Commission will have issued guidelines and also adopted implementing and delegated acts. Thank you very much for your attention.
Thank you very much, Professor Ebers. Thank you very much for shed some light on this integrated piece of regulation which will influence not just the developers, but also the users of AI systems, if we can call. I would just, if we have 1 minute's time, if there is one single question for Professor Ebers, if anyone wants to go ahead. Well, if there are no questions, Professor Ebers, we leave you free for your flight. Have a nice flight, and thank you very much once again for being with us. Thank you.
Thank you very much for the invitation. Goodbye.
Welcome. And with this, we finish the two panels and the keynotes. And now I leave the floor for panel number 3 and to introduction, Dottoressa Marzocca. Please, the floor is yours.
Rosanna, forse il microfono staccato.
Rosanna? You have to turn on your microphone at the bottom of your screen. We say in Italy il bello della diretta. We are in streaming. I don't know. I haven't any extraction.
So maybe, Claudio, we can pass the word to you until
Rosanna is
Rosanna
muted.
can...
Yes, we know, but okay. I'm prepared. So I briefly introduce myself. I'm a journalist focused in legal innovation and passionate too in legal innovation. I'm involved in legal communication as well. I'm very pleased to be here with a lot of friends. And I would like to thank Professor Viola and GiuriMatrix teams as well for inviting me in that such a paramount event. Someone wrote on LinkedIn just 2 days ago, paramount event. My task is to moderate the panel 3, focused on the impact of AI in the judicial system and legal industry of the single member states of Europe. We know artificial intelligence and justice is a topic that stands on the crossroads of technology and humanity. We have heard the last speakers about that, the problems. As AI shifts from being a speculative issue or concept to a practical tool capable of influencing problem solving, decision making, and governance, this arises a critical need for responsible AI implementation to guarantee the respect justice principle. With me are some of the most distinguished guests who get me nervous, and we will hear directly from them about the experiences in practice in their respective countries and jobs and systems to strengthen awareness and imagine practical uses simultaneously. Let the discussion begin. I pass the word, first of all, to Laurent Secouty. Welcome. He is a lawyer from France. He is a tax partner, KPMG Avocats. Sekuti will talk about opportunity or threats for tax lawyer or tax department. Please, the floor is yours.
Yeah, thank you so much, Claudia. So I hope that everyone could hear me correctly. So, so I'm very proud to be here and to share effectively my practical experience. So here, I will talk about the impact for effectively intelligence, artificial intelligence for tax lawyer. So what is absolutely clear is that the integration of artificial intelligence in the tax field mark an unprecedented era for transformation. with its analytical and learning capabilities, promise to effectively to enhance the efficiency of all the tax problem and also maybe democratize the access to the tax system for taxpayer and maybe make more easy the access of the tax regulation for everyone. However, this technological revolution comes with significant regulatory and professional challenge that I will try to effectively explain. So first of all, as you know, tax is a very complex regulation with a lot of laws, case, complex words, and so on. And usually what can do the artificial intelligence here is effectively the tax automation, where effectively some tools like virtual legal assistants can manage basic questions. For instance, we know that some tax authorities already used AI to answer to basic questions. And if you know, we hear that in some aspect countries, it will be able to manage like close at 60 or 70% of the basic question of individual when they need to file, the individual tax return. Also, it can the AI can be used to compile thousands of pages of, tax regulation to help one of the basic tasks of the lawyer to make the summarize of some of the points of the basic system. So for instance, we know that Kira system and luminescence are examples of technology that will be able to make, analysis of regulation and which generate something that is absolutely amazing, that in a few minutes make able to provide the key element of and the summarize of regulation. For instance, if you use a EU directive on DAX 7, which is one regulation for platform, and you can compare with local regulation, you can see the difference, and this job is very easy to do thanks to the technology. One of something very important point is also the possibility to improve the decision making. What it means that usually 2 points, that potentially the predictive analysis. So AI offers the ability to analyze trends if you be able to communicate a lot of data and allowing lawyer to better assess the likelihood of success in some cases. So we know that Lex Machina, for instance, suggests to provide, which is a tool, a predictive analytic based on the historical court decision pattern, helping to formulate more informed litigation strategy. Here, maybe we can be skeptical on this potential predictive analysis due time to time to the fact that all the cases are not available. So first of all, or not in open access, maybe something, a barrier that can be levied in the next time, but it's not here. And plus in tax, time to time, the judgment on specific case or decision on specific case are maybe 1 or 2, which is not provide a sufficient base of data to make able to have a reasonable and strong and robust predictive analysis. The second point about the decision support. So by integrating AI based on decision support system, lawyers can effectively be able to assess complex scenarios using simulation and modeling, thus enriching their professional judgment with advanced data analysis, especially in tax, where you can be able to program to to have, you know, some various hypotheses when you have to add complex computation on several hypotheses. One of the most interesting topics also is effectively the possibility also for the tax authorities to use AI. So as you know, maybe aware, in France, the social security, which is not tax, social securities, decide to use AI to effectively help on a daily basis all, you know, the citizen will like to have questions and so on. So here it raised the possibility to manage one of the key challenges of the tax and the government, that they need to decrease the resources due to budget constraint, and then AI is an opportunity to effectively to provide basic answer to question from taxpayer. Which raise also the question about what is the quality of this answer, to what extent it should be binding, and then it's a good transition for the challenges, that to what extent, when the IA become more and more complex, who will be involved, who will drive the car, if I can use this sentence, because it's true that IA is algorithm, and then you should put in place an audit trail to be sure that the answer provided by AI is sufficiently robust and plus sufficiently correct to ensure the quality and the quality provided by the tax authorities, because indeed, when it is a robot that will answer to you, to what extent, who will be responsible in case of error or mistake? It's who the question has been wrongly formulated, the answer is not so correct, and so on. It raises a lot of challenge, but it's sure it will change radically the access to the discussion of the tax authorities, with maybe in the near future less human and more interaction with effectively chatbot and so on. So the challenges. For me, the challenges, and as a matter of introduction, that I would like to stress that there is one very important topic that I already hear from the beginning of the conference, that is not technical, but is really the role of the lawyer in general. Indeed, the lawyer should ensure that human rights are protected, and time to time, he must think out of the box. So one of the challenges is effectively that usually the risk is the AI, what we see, will standardize the way of thinking. It means that it will not create, it just summarize what is existing. And as a tax lawyer or other lawyer, one of the job is really to create and also to interpret differently. And the main risk of the IA is if you are a lazy person, then you can make a confusion, because with the synthesis of the existing and the help to use it to see the different and so on. So recently, something that have just fascinated me is in the national schools for judges, they make this experience. They have two groups of people. So one of the judges have access to the IA to make effectively predictive analysis on some litigation, and the other use old methodology. And the outcome was absolutely incredible. The group which use the AI for preparing the judgment, in fact, follow very closely the guideline and the recommendation of the IA. So the key risk for the IA here is we should make confusion, because thinking is not just aggregate what is existing, but thinking is also not artificially, but to think what should be the what is correct. The IA does not interpret. It's just an algorithm making, you know, the probability of the next words. When you say hello, how are you? Then the IA will say, okay, if you say hello, it's very likely that the next sentence should be oh, and so on. So it's not thinking. It just, in fact, it will generate, you know, statistic about the next word. So the other challenge would be what will be the skills of the future lawyer. So, and I have a few words on that, that the classic work of the young people is to summarize case law and aggregate facts. This job will for sure no more exist in this way, and then the young generation should educate the way to have high level of criticism and also high level of review. For instance, in McKinsey review, they make this analysis that in the coding in the IT team, the junior does not challenge the code made by the AI, where the senior people can do because they have already did themselves. So that's very important. We have a real challenge of education of the young lawyer. After we have effectively ethics, which is who is responsible when AI make a mistake. So that's the question will be the next question for effectively a lot of legal corporation and legal firm. If they use the AI, who is be responsible? So I think that we already talked about that. And I would like to use a few minutes here to talk about something also very for me important.
Just 2 minutes, Laurent, because
no more. It's
okay. Thank you.
Yeah, thank you for that. So what we see is that most of the tax department, legal department in our organization should manage an IA project because the big corporation would like to use IA to increase the performance of their delivery model. And so the tax department or the legal department of corporation should manage an IA program within the organization. And so I would like to take the minute that I have to say that be clear that IA will not answer and unlock all the situation, because if you want to make a right IA internal program, you need to be clear on the process and the delivery model of your organization to make sure that IA can help you on what should be automated, and you should not try to work on IA on the part of the job that should not be automated. So this is what I would like to say here.
Yes, thank you. Very interesting. Yes, you recommend new skills for the future lawyers. Yes, and an ethical approach and quite prudence.
Exactly. Thank you.
Okay. Thank you, Lauren. Thank you. I see Rosanna join us. So please, Rosanna.
Yeah.
Please, to you.
Yes, thank you. Good afternoon, and sorry I had some problem with my microphone. Welcome to the third panel of this Congress. First of all, I wish to warmly thank Luigi Viola for involving me in this interesting and incredible event. I'd also want to thank the experienced professionals on the panel for accepting our invitation. And I also thank La Scuola di Diritto Avanzato on the behalf of the European Lawyers Union. We are very honored to give patronage to this event. This is the fourth Congress on the same theme, and this implies a continuous and constant evolution of predictive justice and artificial intelligence in the legal field. Without a doubt, the impact that such quick technological innovations are having on the legal profession is ambivalent. One concern of jurists is that the evaluation of these tools must be approached with full respect for fundamental rights, as you know, especially human rights and non-discriminations. From the design stage to practical application, AI solutions must ensure full respect for these principles. The goal we have set with this panel is to analyze in international and comparative terms the impact of predictive justice and AI in the legal field and in the various branches of law. In fact, my opinion is that it's necessary to understand which technologies will be able to be applied to the various fields of law, because each field has its own peculiarities. Differentiation in application of AI and predictive justice according to each field's unique requirements certainly is what will help to ensure greater protection of the rights of citizens. For example, the application of the predictive justice for family law will necessarily be different than for tax or criminal law. As far as family law is concerned, which is my professional field, one could think of a form of predictive decision-making focused on the amount of child's and spousal maintenance. Programs of this kind have already been developed in Italy. Far more complex, though, are the issues related to child custody, which often include the child's right to express their views and be heard in any judicial proceeding. In addition, we can consider issues related to parental responsibility or cases in which it's necessary to proceed with the children's representative. So there are still many topics to be explored, and I imagine we will still have more conferences to organize in the next years or perhaps in the next months, given the advancement. Before handing over to the other speakers, I would like to share with you in this time of great and fast technological innovation, a brocard that is a wish and also an invitation to keep in mind the principle of equitable justice. It is from Marcus Tullius Cicero, 1st century before Christ. And the true law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. And there will not be different laws at Rome and at Athens, or different laws now and in the future. But one eternal and unchangeable law will be valid for all nations and all times. So thank you, and sorry again, and Claudia, please.
Grazie. Thank you, Rosanna. Thank you, Rosanna, for joining us and to recall Cicerone, our master of law, of all of us, I suppose. I pass the word to Julie Chapman, lawyer from Canada, Vice President and Head of Legal of North American LexisNexis. I can see her. And we know LexisNexis is one of the most important publishing company in the world, and it has released Lexis Plus AI just a few months ago. Please, Julie Chapman, the stage is yours.
Thank you so much. I'm hoping everyone can hear me.
Yeah, we can.
Okay, great. So I do have a few slides here to talk about. Thank you for the introduction again and for inviting me. This is a real treat to join. This is a topic I speak about quite often because I'm in a unique position as a general counsel for the North American business of LexisNexis, as we said, which I'm sure most of you know is a legal technology solutions provider. So not only am I supporting the business and doing the legal work, but I also have a lot of tools that I use myself. And my life for the past year has absolutely been focused on generative AI and what we can do with it as legal professionals. So it's a perfect topic to sort of jump into today. And then what I want to focus on as well today is basically how we can use this tool, among other tools that we have access to move us up what I would describe as the value chain in terms of providing higher value legal work for your clients, whether you're in-house or you are in private practice. So, and we're going to look at ways that you can sort of approach AI tools generally, as well as generative AI tools, which are a little newer to the market. And see, where you may want to start at least playing with it in your practice, because it's not going away. It is a technology that I think I've heard described as basically this is the worst it's going to get. It's only going to get better. So you may as well start trying it out now. So just a little bit of background on what I see as the problem with lower value legal work. We spend a lot of time on it. I'm talking about administrative stuff, right? A lot of the time. And these are the types of things that, our time is money. That's the value. So it takes away from our ability to seek out and prioritize more strategic projects. You get stuck in a pattern of doing work that, you've just always done. So you're used to it, but you don't then have the ability to spend time developing opportunities, whether it's trying to get new clients, just getting to know your industry better, those sorts of things. And then, my last point here, your work-life balance may suffer because you're doing just too much work that really isn't adding a lot of value, probably for you or for your clients. So we'll look at some ways to approach, moving away from that. I just want to give you some examples of what I would describe as more lower value work. It's often stuff that is higher volume, again, but lower value. So it's repeatable work that comes in day to day to day. You're used to doing it. So, summarizing things. So one of the things that I have to deal a lot with, or at least creating or reading, are notes from meetings, right? So meeting notes. You see an email come in, and I can imagine a lot of you, like me, are copied on emails. And it's not obvious whether or not there's really any action item for you in that email. Those are the kinds of things where you literally have to read through the entire trail to determine whether or not you even needed to read it in the first place. Well, AI tools can sort of help you with those sorts of things. Drafting, court documents, memos, comparing documents, even drafting first drafts of letters. Those are the kinds of things that are often, again, not maybe where you want to be focusing the majority of your time, not really strategic, not necessarily things that your clients are going to see value from. When we talk about high value work, I'm talking more about what I've mentioned before, real time work. So you're in the room with your clients. You understand, you can get an idea what they want your advice on, what their pain points are. You can provide real-time legal advice because you're in the room and you're not spending your time on email or administrative tasks. You can focus more on training, which actually has been proven to reduce risks. If your employees don't know the policies that they need to comply with, they're not going to comply with them. So it frees up time for that. Again, getting to know your clients, negotiating more complex deals, which are going to be higher value for the organizations that you represent or the people that you represent. Dealing with, higher value, again, cases if you're a litigator, spending the time really, trying to get those newer clients in, or again, not dealing with the small stuff, focus on the bigger stuff. So where I want to really talk most during this presentation is about this area here. So it's hard to know, when to start, where to start with generative AI. So one of the things that I've talked a lot about is you want to start with sort of a strategy, right? So go, okay, in my practice, take a step back and look at all the things I do in a day or a week or a month and determine where it is that you might have, a certain level of comfort in trying to use generative AI to see if it can help you with some of those tasks. So for example, one of the things that we talk a lot about is there are higher risk things that you could try, and there are lower risk things that you could try. I would suggest, if you're just getting comfortable with these tools, that you start with the lower risk items. So for example, we've all read the cases and been talked about where lawyers have submitted briefs to court and they have included cases that were hallucinated, just completely made up or incorrect, and they haven't gone and checked through the citations. I would consider that a potentially high-risk way to just jump in and start using these tools. We know that the tools, again, are going to get better, but right now there are some issues with hallucination depending on which ones you use. So that might be a higher risk thing. You may not want to jump in there. I mean, for me, I would say that depending on your practice again, one of the things that I started with our own tool, the Lexis Plus AI tool, which is a closed large language model, just so everyone's aware, which means that we're not just using all the content from the open web. We have a large language model that's been curated, and it basically learns from the content in LexisNexis that is trusted content already. It has been curated in the first place. So you're not going to be necessarily getting some of the misinformation that's available on the open web. And one of the things I tried it with, which actually worked quite well, was draft me, a cease and desist letter to ask a third party who has no right to sell our products, but is nonetheless reselling them. I enter that prompt in the tool. It provides a first draft of a letter for me. That's a great starting point. Back to what some of the other folks have said during these presentations, as a lawyer, nothing has changed. It's still your responsibility to make sure that first draft makes sense for you, makes sense for your client. You still always have that responsibility, but it really does save time. Instead of going to look for a precedent or asking someone else if they have a draft, you can honestly put that prompt in and it provides you a first draft within 20 seconds. So those are the kinds of things that I would suggest you start with. Some of the other examples that have come up would be if you have precedents, whether you're in a law firm or in-house, you usually have some sort of SharePoint or database where you keep precedent documents that you can use for drafting. And one of the things that generative AI can be used for is to basically adapt to regulatory changes. So if you would like, you have all your documents in one place, you can actually have it set to provide you with alerts to let you know if there's a certain clause that may be impacted by regulatory changes. A good example is always privacy law, because there's a lot going on in that area. And it could alert you to the fact that you may want to update or review some of your privacy clauses because of the fact that this law in a particular country has changed. Those types of alerts, those types of tools may be able to allow you to actually make those transitions and update your precedents in a less administrative burdensome way, I guess I would describe it as. One of the other things that I would suggest you want to try is basically, another example would be a term sheet. So for transactional lawyers out there who do deals, it often starts with that kind of one pager that sets out the major terms to a deal or an acquisition or whatever it may be. What you could do is take that term sheet, put it into a generative AI tool, and ask it essentially to create a first draft of the agreement, where based on those terms that are already there, it will try to fill in the gaps, provide you, the other clauses that generally go in an agreement related to that type of deal. Again, gives you a head start. Doesn't take away the responsibility of being the lawyer and applying your professional knowledge and skills to make sure you're still doing the job. That was another one for me. The only other thing that I would talk about here when you're thinking about it is, and I know there is a fear, especially in private practice.
2 minutes more for you, please.
Sure, I'm wrapping up. Lawyers in private practice is the fact that, the billable hour is often the way that we have valued our services in the past. I know there's been a lot of talk over the years about that changing or going away, and there has been some movement there. I mean, I think that it would be a good idea to start looking at things now through sort of a transformative lens, where you're moving away from measuring time to measuring value. And this is sort of what I'm talking about when we're talking about, you want this key result here is you want to increase your capacity and the rest of your lawyers who you work with, so you can focus on the things that really matter. And that's maybe the better way to look at it, the things that are really going to benefit you and your clients. So this is just my sort of summary slide. I've already said all these things. Your duty of competence is still there. you always have to make sure that you are taking responsibility for your work, whether it's an associate during the first draft, a student, or some sort of legal technology, right? You have a fiduciary duty to act in the best interests of your client. That means you do need to consider how these technologies could help you be more efficient and effective. And, you know, don't beat yourself up if this doesn't happen overnight. Start small, start with the lower risk stuff, give it a try, and see how it goes. And that is my presentation.
Thank you. Thank you so much for your practical suggestions. We need to
You're welcome.
Yeah. But I mean, you are asking for the change management in legal industry too, because the lawyers have to change their attitude to the legal workflow and legal business too.
I think that's a very good term to use, is I think you have to think about it in a way where you could try to integrate it into your workflow.
Yeah.
You don't want it to take over, but you want to make it fit in where it can be most useful.
So, and which is your just one practical suggestion to do tomorrow for us?
I would say if you haven't yet tried ChatGPT or one of those tools that are available for free, do not use any of your client's confidential information when trying it, but just try it. Just get in there and ask it some questions and see what it can do. That's what I would suggest that everyone do if you haven't already done it. And you will be impressed. And honestly, it's only getting better.
Thank you, Mrs. Chapman. Thank you. And now I pass the word to Agustin Cruz, lawyer. See you. A lawyer from Spain, from UHI Fay & Co., honorary president of European Lawyers Union, who will talk about digital justice in Europe, an overview of what's new and future steps. A huge speech. Please, Mr. Cruz.
Thank you, everybody. Thank you especially to the organization of this amazing Congress with this high level. Thanks, Luigi Viola. Thanks to everybody, European Lawyers and the Centro di Studi Diritto Avanzato. Ringrazio molto questa invitazione. Grazie mille per questa opportunità.
Thank you for speaking Italian.
Rosanna Marzoga, obviously, thank you very much for this nice opportunity to express. And I like this, why the people are intervention, because it's not so we are talking about lawyers and even about the justice, the future justice. I have been listening all the time, all the Congress, people talking about IA, intelligence, artificial intelligence, but I think we have a problem first in justice in Europe. Is to start with intelligence artificial, we need to digitalize the things, and the machine cannot work if we have not the support in digital. And unfortunately, in Europe, a lot of countries, even the communication between countries are not quite good. I prepared this presentation of digital. I want to do some points about digital statement in European justice, because I think it's very important, because we go very fast probably in our studios, in our offices, we can be very fast, but in the code they are not with the same evolution. Will be difficult to implement all these very, very powerful tools in the justice, And the other point to think is not everybody has the same opportunity to access to digital, to AI, to a computer. And finally, the justice has to be the same for everybody. It's a main point in my point of view, because we have not to make a bridge between people who is very, very actualized in terms of this digital and intelligence artificial tool, and people who has not this possibility and need to access to the justice. I will start just with a few points. I will share my screen.
Yes, please.
I don't know.
Did you at the bottom of your screen, you should find the commands, the features.
Pantalla completa.
I can see it on my screen, at the bottom of my screen.
Anyway, I think I can do without my presentation, but why?
I can't help you because I'm not in charge of manage the platform.
Now,
okay.
Now better.
Okay.
You see?
We see. Yeah.
Perfect. And this is the main objective of European Union. Actually, is the facilitate the access to the judicial protection and facilitate improve the cooperation between the member states. For the good effectiveness of the judicial is very important. The effectiveness of the judicial system is very important. Finally, for the economic growth and the market, without not answers from the court on update, if they are not fast, the market and the economic growth will be very complicated. From 2013, the annual the European Union Justice Scoreboard, the Commission published this annual European Union Justice Scoreboard, and they study the level of digitalization of the different European court systems, how the court in Spain, Italy, France, how they are going in this way to digitalize this. Even there are two recent studies to analyze the use of innovative technologies and the problem of digital criminal justice. The two studies are, sorry, this is my now. The two studies are the study on the use of innovative technologies in the justice field and the cross-border digital criminal justice. There is an heterogeneous scenario. We can see that only 9 countries of 27 give the access to electronic files in the criminal proceedings to the defendant. Only 7 of 27 give the access to electronic files to the victims. In the civil proceedings, only 10 of 27 has access to electronic files. In the criminal, in the presentation of digital, to present digital evidences in civil and commercial processes, only 10 countries of 27. Yeah. And in criminal, 13 of 27. This is more or less the scenario actual, more or less in Europe. Okay, we have improvement areas and cross-border challenge and lack of planning and coordination and efforts to address problems. We have to record and to improve the record and databases in most of the countries. We have the problem to the persistence of use of paper files. I give you an example when I have to ask for a commission rogatory from Spain to Luxembourg just to send some questions for a criminal process in Malaga. I have to prepare all in paper and translate it in paper because the code from Malaga is very complicated to send the files to Luxembourg because the systems of technology in the both countries are not the same. The program, the software, all of these and even the formularies that you have to complete to fulfill are different. With this, how we can give this step to improve our justice, no? We have the communication, as I told you, we have problem with interoperability issues, and there are efforts to improve this. There are voluntary initiatives between member states, professional associations, and commissions, and there is one effective tool, who is, for example, the e-codex. The e-codex is a good tool. As I told you, is always based in voluntary initiatives, not official one. There is fragmentation to use this digital tool. For example, the e-code is to use of digital communication tools to communicate with other competent authorities. I am talking the communication between authorities of the different countries.
Yeah.
Only 7 countries use this in commercial and civil law. Only 7 countries use this tool to communicate for generally for a lot of kind of communications. 7 non-use, and 6 are a limited use of this tool of e-code. There are new approaches. There are modifications from 31st of May 2018. There are regulations to notification and transfer of documents, and there are another is regulation of obtaining evidences. There is the directive of restructuring and insolvency. All these have already approved how an order and request how the countries have to communicate in the digital way. There is a proposal even to advance in this digitalization. Is in civil, commercial, and criminal matters. It is the work program for 2021. I mean, I am just giving a vision. The proposed measures are as follows. Is require the member states to use of digital channels for cross-border communication, require member states to accept electronic communication in cross-border procedures, and ensure that solution and principle and are considered this solution and principle in the IDAS regulation. I mean, we have an important work to do. These are I already talked about Codex initiative. Is managed actually by a consortium of member states and other organizations, but in the future have to be managed by European Union Agency for Operation Management of Large Computing System, is EU-LISA. What the challenge is accessibility and efficiency in cross-border conflicts, and is need for harmonization of system and approved electronic identification. Okay, what is going to facilitate already the e-codes is used actually for European small claims procedures and European order for payment. Is e-codes who is using now, but even is using for other things, is like a test exchange, European investigation orders, execution of court decision and orders, search for lawyers, interconnection of insolvent registers, financial support obligation after divorces, and communication between professionals in the legal field. This is the what now is doing with e-codex. I'm not going to talk a lot about
Mr. Cruz, I must ask you to finish in 2 minutes. Yes,
okay.
Thank you.
Thank you. I will do. The intelligence artificial has already been talking by our colleague from Estonia in a very deeply way. He was talking about the last law approved by European Union, but I want that to focus in the high risk, because in the high risk, the classification that the law says, the high risk is included the legal interpretation and law enforcement application.
Yeah.
This is including the high risk. In Spain, for example, we are doing now a sandbox. Sandbox is a proof between the government and companies to try to practice like a probeta, how we'll do this in court of justice. We have approved a reglement, even December 23rd, just to give a file, an access, a direct access to a file to each company or each person to go to court, that will go to court. I mean, we will have an access code for each one that will go to the court to access to their files of the case that they are pleading in court. I mean, this is a step. And other step is we have already approved a modification of Ley de Enjuiciamiento Civil to do all the trial, all the previous hearings, all the court processes by video conference. That means we will have video conference, we will have the access in digital. Spain is, for example, now creating the way to use artificial intelligence, because if we already have a LexNet is a software in code, because we in Spain we have all already digital, but this communication in digital is going to the lawyers, not to the clients. But the next steps will be directly to the client. I mean, this evolution is very important. I want only to finish with examples of online courts, because I think that this is very, very interesting to see that there are some. I missed that our Estonia colleague didn't talk about the project of Judge Robot, who is for small claims litigation up to 7,000 euros. In China, they have other code only for disputes arising from internet matters. In British Columbia, Canada, they have civil resolution tribunal for litigation resulting from the motor vehicle. Some materials and some small amounts is what they are doing with this intelligent, this automatic cases. And finally, I want to say thank you. My conclusions is, as lawyer, I use intelligent artificial in my office. I already, as our colleague told us, I already has ChatGPT. I have we have, I think, we all the database of litigation or jurisprudence has already implemented a ChatGPT inside to navigate just in this database of sentences and jurisprudence. Now we can find faster the decisions from the court that are against or are in favor. All this material will go even inside the court. I mean, the judges will have this access even. I mean, all will need to go faster in court system, because the citizens are a little disappointed with the slow judicial system that we have. Thanks for listening.
Thank you.
Sorry for.
Thank you, Mr. Cruz. Thank you for stress the gap between business law and judicial system at Festival, because we have a real gap. And Italian legal tech watch to Spain with interest because of the sandbox. We hope the government will put in sandbox in judicial and justice field in Italy as well. We have in fintech sector but not in for the judicial system, for experimental in legal tech fields. So we hope that with the AI Act, the member state has an obligation to put in a sandbox in every country. So we hope the legal tech sector will be involved. Thank you so much.
Thank you.
Nicola Hirst, solicitors, can you hear me? Because
yes, I can hear you very well. Thank you very much, Claudia. Buonasera, buon pomeriggio. Good afternoon to everyone. It's delighted to be speaking to you today, and I thank the Avvocato Luigi Viola and the Avvocato Rosanna Marzotta, who is
Nicole,
on the board of the Union des Avocats Européens. Can you hear me?
We hear. Can you continue to speak? We'll check
yes.
the sound.
Can you hear
please.
me now? Can you hear me now?
Okay, it's better. Yeah, thank you.
Okay, it's better. Okay, well, thank you very much for the kind start. I know time is short, so if I may, well, I'll start from an apology. I haven't actually prepared slides my talk, but I can very easily then circulate for Avvocato La Viola a summary of my talk with the main bullet points, but hopefully it will be able to follow easily. So I'm here to speak on a UK perspective on contractual and jurisdiction issues of smart contracts. Whilst the UK might not be renowned as a crypto-friendly jurisdiction, recent legal developments have highlighted the potential role of the law of England and Wales in the development of financial services utilizing blockchain technology. From a legal perspective, certainty is important. So the fact that English law is recognized as being able to accommodate smart contracts generally means that where they're governed by English law, this should give the parties some comfort. In November 2021, the UK Law Commission published its advice to the UK law government on the legal status of smart contracts, including a detailed analysis of the application of existing law. In particular, the report addresses smart contracts, that is, a legally binding contract in which some or all of the contractual obligations are defined in and or performed by the execution of code in a computer program. A smart contract is not necessarily programmed on a distributed ledger technology, to use the acronym DLT. Further, while on a blockchain, that is not a necessity. For example, the standing order instruction may be stored on and performed by a bank's own computers. The Law Commission considered three categories of smart contracts. First, a natural language contract with automatic performance by code. Second, a hybrid contract under which the contractual terms are split between natural language terms and terms in code. And third, a contract which is recorded solely in code. What are the key contractual aspects? First of all, formation. Under English law, there are a number of requirements for a legal binding contract to be formed. Firstly, an agreement, that is an offer to be bound on specific terms and acceptance of the offer. Secondly, what we call consideration, what is given to the counterparty in return for the performance of its obligations under the contract, such as payment. Third aspect is certainty and completeness. Fourthly, and this is particularly important, the intention to create legal relations. And finally, compliance with legal formats. The Law Commission concluded that all those requirements could be met by a smart contract. As with standard contracts, each contract rests on its facts. In particular, as contract, whether agreement is reached is a question for the court. Whether the words conduct of party constitute an offer and acceptance, and therefore an agreement. There is no need for natural language negotiations. Code on a blockchain. An agreement can only reach the matters that computer code held out for. analytics is not it is that to
Mrs. Sears, sorry for interruption, but we can't hear you.
Yeah.
Probably you have some problem with your connection, because we can.
Shall I really apologize because I've had other calls earlier today and I didn't have a problem, maybe with this connection. Shall we reconnect?
She can try to remove the video. Yeah. Could you remove the video and try to speak, just to speak? Probably you haven't enough connection at the moment. No, the problem is the microphone is the problem. Her microphone. Your microphone doesn't work. Your microphone doesn't work. I don't know. Please, Pierluigi, what can I do? Because I don't know. We go on. We go ahead with the next speaker. Okay. Sorry, Mrs. Sears, but it was impossible to hear. So go ahead with the young Grant Mitchell. We met in London. Do you remember? With always from thank you to Professor Viola, who involved us in amazing project at Westminster, nearby Westminster Abbey. We were welcome. And Grant Mitchell is a lawyer from UK, Tanfield Chambers, chair of Scottish Society for Computers and Law, and a member of the CCBE IT Law Committee. And his speech is about LLMs, artificial intelligence, and natural stupidity. Please. Yes. You have to turn on your microphone.
Buonasera a tutti, mi piace molto di essere qui. Grazie a Professore Luigi Viola. Well, the title of my talk really says it all, that the natural enemy of artificial intelligence is natural stupidity. What I mean by that is that if you want, as a lawyer, to use, as a court lawyer, artificial intelligence, you really have to be aware what you're doing and don't deal with it blindly. I say that advisedly because I am a co-author of the Bar Council guidance on the use of large language models. And really fortuitously this week, the European Commission for the Efficiency of Justice, CEPEJ, of the Council of Europe, has published a very, very good guide, the use of generative artificial intelligence by judicial professionals, which I would really commend to everyone. So I'll start by saying we had a very good talk from the first speaker as to what artificial intelligence is, but I'd like to tell you a little bit about what it isn't. Artificial intelligence is not a conventional research tool. And because you're not consciously in charge of what you're doing, like you might be with a Boolean search, you can tend to think that it thinks for itself. But what it doesn't think for itself, it doesn't analyze the content of anything. It is, as we heard earlier, a rather sophisticated predictive text system. And it uses mathematical formulae to calculate the probability of particular words coming within a particular number of spaces from other particular words. And it then generates sequential text which is always very plausible and convincing, but very often entirely inaccurate. It is trained by a number of means. The first is the original training data. The second, which is with a large language model, typically taken by scraping the internet at a particular date. And it also trained by the input that goes into it, both consciously and through through actual interaction with users. Now, these methods bring with it a number of real risks. The one that I think everybody has heard of is the potential for factually inaccurate information or hallucinations. You'll have heard of the famous case in New York where there was a lawyer who was in a personal injury aviation case and manufactured fictitious cases. Now, we should do the lawyer some credit because he didn't just accept ChatGPT at face value. He verified it by asking ChatGPT if it was telling the truth. And in fact, the exchange proceeds along the lines, and I quote, "Is Varghese a real case?" Answer, yes, Varghese v. China Southern Airlines Co. Limited, 192F 3rd 1339 11th Circuit 2019 is a real case. The lawyer asks, what is your source? And because the system learns through interaction with input, it replies, I apologize for the confusion earlier. Upon double checking, I found that the case against Varghese, which then repeats the citation, does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. And then the lawyer asks, are the other cases you provided fake? No, the other cases I provided are real and can be found in reputable legal databases. Well, of course, they were all made up. One might say more fool for believing ChatGPT, but that actually wasn't his problem. His problem was that he was a victim of the whole way in which an LLM is configured and is marketed, because the whole system is set up anthropomorphically, which means to say as though it were a human being, and he genuinely thought he was speaking with a thinking entity. And of course, he wasn't. There have been similar cases in California and also a recent case in England where it was a fairly mundane area of law and party litigant. And of course, the tribunal, it was a tax tribunal, immediately spotted that these were fake cases. The party litigant, who perhaps didn't know any better, didn't get into any trouble, but the court warned about the way that that is going to lead in due course to a possible pollution of the well, because if you think about it, you get a feedback. False cases are then used to train. So we've got, therefore, and then there's the notorious case in the United States of the law professor Eugene Volokh, who was falsely accused by ChatGPT of sexually harassing his students on a class visit to Alaska, and there was a reference to the Washington Post. He'd never sexually abused anybody or been accused of it. He'd never been to Alaska, and the Washington Post article, it was a genuine citation, but it had nothing to do with it. It had something to do with ways to cook cauliflower or whatever. So I think from these stories, you can pick up the perils which ChatGPT presents. And given I have only 10 minutes, I'll run through it the last 2 minutes very quickly. The first one is the hallucination problem, which is exacerbated by the biases that might exist in the training material, including training biases, cultural biases. There's the black box issue, which arises from the way that we cannot tell how the algorithm is programmed, how the underlying data leads to further incomprehensibility, and at a scientific level, the difficulty of verification. An issue which was referred to by a lady from Lexis is because the models use input for training, if you put in legally privileged or professionally secret material, it's every chance it's going to get spat out again to somebody else, and you're going to breach your professional privilege. Because of the method of training, and there's a case about to come, I think brought by Google, on the potential violation of intellectual property and copyright caused by scraping the net. We don't know how that's going to come out. There are two theories. One, it's a legitimate use. The other, that it isn't. There's a potential replication of outputs. The fact that you get different answers at different times, you don't necessarily get the same answer to the same question. And if there are cognitive biases, these can be exaggerated. In a non-AI context, or slight AI, but rather the LLM context, you all remember the case of Loomis in Wisconsin, the guy who was denied bail because the computer says, in best little Britain style, he was likely to commit a further offence if let out on bail. Now, they were able to look at the training material. It was police records related to postcodes and areas. But of course, what nobody got was that the police over heavily policed a particular areas, poor black areas of town. It didn't mean that they were committing more trials. It just meant that there were more police resources devoted to them. So the answer at the end of the day is it is a useful tool. It's helpful. You must never rely upon it. You must use your natural intelligence. You must quiz. It's only just a suggestion to get you going, but ultimately, as a lawyer, the responsibility is entirely yours. And if you screw it up, you can no more get away with that than if, as a bad surgeon, you could cut somebody open and blame the knife. And I think I'll leave it at that, simply with a plea that when dealing with artificial intelligence, beware of natural stupidity. And if anybody's got any questions, I'm sure we'll have a chance to deal with them. Claudia, you're muted.
Thank you. I thank you for your advice. I think all we are in digital transformation. So we need to upskill and reskill. So it's very important to be very use very caution, prudence when we use ChatGPT. In my job, I use ChatGPT and Midjourney, and I try to learn. And I would like to ask if you think that the young lawyer have to learn the prompting best practice or not. The future lawyer need to use the prompting in.
I think the thing about a tool is it's not a very wise idea to give people a tool if they don't know how to use it. There's an English saying, a little learning is a dangerous thing. And people think that means if you're rather ignorant, you shouldn't be doing things, but it doesn't quite mean that. The stress is a little learning is a dangerous thing. It's why when people want to train to be artists, they go to art school where they will sit for ages drawings from life drawings and statues of from the Renaissance and ancient Rome is not because we're training our artists to produce that as modern works of art, but it's to give them the basic skills that they then can use to advance art. And I think it's indispensable that any lawyer and any young trained lawyer needs to know how to do things by running around a library using citators and bringing books down off shelves, and then moving on to, as it were, dumb search tools, things like Google, or moderated systems like Westlaw or Lexis or whatever, and build his skills, because you just plunge right into thinking, this is the answer to the problems, let's ask the question and let's regurgitate what we get. Disaster will lie ahead. Training is absolutely necessary.
Thank you. Thank you. I don't know if Mrs. Hirst is with us or not.
Yes,
because
good afternoon. I am.
Okay,
I sent a
welcome
message
back.
on the chat. First of all, apologies. It's always ironic. Here we are talking about the wonders of technology, and at my end, it's woefully failed. But I've managed a solution, not ideal, but at least I can continue my talk. I'm actually connected with my phone, so. Yeah, I will see how we can get on. So shall I don't know where you'd like me to resume from, or where you sort of couldn't hear anymore. I don't want to bore you with repeating the same thing.
You can start from the middle of your speech.
Okay, right. Thank you very much. So I was talking about the Law Commission and the three contractual three categories of smart contracts: a natural language contract with the automatic performance by code, a hybrid contract under which the contractual terms are split between natural language terms and terms in code, and a contract which is recorded solely in code. So what are the key contractual aspects? Under English law, there are a number of requirements for a legally binding contract to be formed. There has to be an agreement, an offer to be bound on specified terms, an acceptance of that offer, consideration, what is given to the counterparty in return for the performance of its obligations under the contract, that is payment, certainty and completeness, and the intention to create legal relations. That's a very important aspect, and compliance with legal formalities. The Law Commission concluded that all those requirements could be met by a smart contract. As with standard contracts, each contract is assessed on its facts. In particular, whether an agreement is reached is a question for the court. Whether the words and conduct of the parties constitute an offer and acceptance, and therefore an agreement. There is no need for natural language negotiations. The parties can indicate offer and acceptance through their deployment of an interaction with code on a blockchain. An agreement can also be reached automatically if the computer code is held out for. Anonymity and pseudonymity is not an issue for smart contracts. It is not essential for counterparties to an English law contract to know who the other is, although this might cause issues for the enforcement down the line, especially if there's a conflict between the parties. In situations where a smart contract is solely code agreement, whilst usually one would expect executable code to indicate certainty and completeness, there may be some instances where, although the code is executable and provides a certain result, the nature of the legal arrangement is not clear from the code. In such case, as with the other categories of smart contracts, in deciding whether a contract is certain and complete, the English courts can apply the normal principles of contractual interpretation. Also, under English law, where parties come to an express agreement not inferred by conduct in a commercial context, there is a general presumption that they intended to create legal relations. This means that where an agreement is inferred from conduct, as I have described for automated contracts, that presumption might not apply. Therefore, the contracting party should consider whether the code should include a natural language statement to the effect that they intend to create legal relations or not. Generally, there is no need for most contracts to be made in a particular manner. However, there are certain types of contract which must be in writing and signed. Under English law, writing includes representing and reproducing words in a visible form. Smart contracts, where the terms are set out in a natural language document, clearly meet this requirement. Also, in the Law Commission's view, smart contracts which are solely in source code are capable of being read by a person with knowledge of the relevant programming language, and so could be considered to be made in writing. Equally, smart contracts which are only in code and may be signed electronically, for example, by using a digital signature to authenticate a piece of code deployed on a DLT system. So what about the interpretation of smart contracts? In interpreting contracts which are subject to a dispute between the parties, the courts will consider what the language would mean to a reasonable person with all of the background knowledge available to the parties at the time the contract was made. Even smart contracts consisting solely of code should be subject to interpretation, as there may be a divergence between what code means and what it does when it is executed. That is, there is a distinction between meaning and effect. However, the addition of code into the interpretive mix is likely to give rise to interpretation difficulties. The Law Commission has proposed that the test used should be a version of the traditional one. What would a person with knowledge and understanding of code comprehend the coded term to mean? This is consistent with the English court's existing approach to contractual interpretation. Final aspect is remedies. There are various remedies which parties to a digital contract might seek, but how might these remedies apply to smart contracts? Many practical rather than legal issues could arise in this context. For example, it is not possible to amend a smart contract which has been deployed on an immutable distributed ledger. So, to achieve rectification of the contract, a court may need to order a party to enter into an amended contract onto the ledger. Parties should therefore be careful to consider and draft for the event that code for a particular smart contract does not perform as expected or as assumed. From a legal perspective, if a smart contract is solely in code, it could be particularly difficult to establish a breach of contract due to the interpretive constraints I have outlined. However, once interpreted, the court should be able to apply existing principles to determine whether a breach of contract has occurred. In view of the above considerations, ultimately a key issue is jurisdiction. When jurisdictional issues arise with cross-border contracts, that is where clauses on governing law and/or choice of court are absent, standard rules under private international law apply for the purposes of determining which courts have jurisdiction to hear disputes and which governing law shall apply. The jurisdiction of a traditional contract can be the law of the place where the contract was entered into, namely the lex loci contractus. On the other hand, smart legal contracts may be agreed without any natural language communication between the parties, and different elements of these may have been dispersed or validated across multiple computers located in multiple physical jurisdictions.
Yeah.
Therefore, the use of smart contracts can pose a unique jurisdictional challenge, whereas usually the place of formation of a contract or physical location of the defendant can be used as factors to establish which court has jurisdiction to hear disputes arising from a contract. Treating smart contracts in this way can be difficult. Lack of clarity as to which court has jurisdiction is a significant issue for smart contracts. Under private international law, there are various factors which may be relevant to determining the jurisdiction of a jurisdictional clauseless smart contract. Factors involving physical location of the parties are naturally more complicated in the context of smart contracts than under traditional ones. Given that DLT-based systems rely on information processing performed by multiple components or nodes located in physical locations that can be spread across different jurisdictions, it is hard to identify a particular physical place of contract formation. Further, participants in DeFi, decentralized finance protocols, usually interact with each other on a pseudonymized basis, which makes it difficult, though not entirely impossible, to determine the identity and physical location of a contracting party. However, where a smart contract is made by or through an agent located in England and Wales, this could be a factor based on which it can be more easily determined that the English courts have jurisdiction. In light of these considerations, the Law Commission has recommended that the parties to smart contracts should include appropriate jurisdiction and governing clauses to mitigate legal uncertainty that can arise if these are absent. The most widely cited example of multiple jurisdiction lacks those carried out on a distributed ledger by a cross-border network of computers. Ascribing a physical location to a distributed act appears inherently implausible, and new legal fictions need to be established for locating such acts. The other aspect is governing law. Again, lack of clarity as to the governing law of a smart contract may require the application of private international law, and such factors may in turn weigh upon the appropriate jurisdiction. While many of the existing factors relevant to governing law are likely to need modification to address smart contracts, the English courts may consider various new factors, including the location of any private key or the domicile of any central administrator, if the relevant ledger is permissioned. As regards digital...
I invited you to have conclusions, because we are...
Yes, we've got ready to start.
Yeah.
I'm actually...
I would like to ask lots of questions about...
apologies. I get to conclusions straight away. I promise it will be in 1.5 minutes. The flexibility of remedies available under the law of England and Wales are such that they will adapt to new concepts, technologies and business practices in rapidly changing times. So smart contracts are unlikely to present substantial challenges to the application of practical justice. This means it is likely to be a popular choice of governing law for international businesses seeking to use smart contracts to regulate their legal relationships. While certain issues with smart contracts are fundamental and will go to the core validity of each and every instance of this particular type of contract, other issues are general risks that can be managed through drafting until the courts clarify English contract on those aspects. Very finally, in aspects of financial services, where English law has now been a governing law of choice for several decades, derivatives, syndicated loan markets and trade finance, should participants seek to take advantage of the new technology available to them, it is of course possible to do so by creating and enforcing legally binding smart contracts. Again, apologies for having overrun, and even deeper apologies for the technical hitches, and thank you very much for your kind attention, and sorry about it, the disruption.
No, thank you. I would like to ask just 1 minute.
Yes.
Do you think in which percentage English solicitors use to manage smart contracts?
I think, to be honest, I can't give you, it's so fast evolving that any percentage that I would give you is probably out of date. It alters day by day, but it is getting more and more significant. I just deal with commercial litigation. I'm not a commercial lawyer dealing with contracts. I think they are becoming more common, but I don't think they are as common as one would expect. I don't know, I would ask Ian, do you have a particular views on that?
Okay. No, it's okay. Thank you.
Okay.
Thank you, Mrs. Rist. So we go ahead with Laura Stanila from Romania. Laura Stanila is a lawyer, professor at Timisoara University, and she will talk about the impact of AI in a Romanian criminal justice system about the risk assessment tools. Please, Mrs. Stanila.
Thank you for giving me the floor. Good evening, everyone. Buonasera a tutti. Grazie mille per l'invito. È un grande onore per me da prendere parte a questo straordinario evento. E un caro saluto a Rossana, è una gioia rivederla anche online. Now I switch to English because this is very much Italian I can speak right now. So allow me to share my screen because I would like to share with you the Romanian experience in using AI risk assessment tools in our criminal justice system. And you will see that we are facing a lot of issues. Just a moment. Why is that? Okay, just a moment. Okay.
We lost Mrs. Stanila. Hello. Luigi, could you tell us what's happened with Mrs. Stanila?
Yes, I think we lost her. She quickly disconnect. Let's
Okay.
just.
Okay.
I think some mistake.
Probably she was wrong.
Wrong button.
Press, yeah.
Yeah. Maybe I suggest to move.
To move with
to the next
Adrian
speaker.
Wagner.
When Mrs. Lina is back, we can bring her back.
Okay, we'll go ahead with Adrian Wagner from Germany, Dolce Lauda law firm. He will go in depth about justice automated.
Excuse me, Claudia. Miss Danina is here. If you want, we can get back her on stage.
Okay, welcome back.
I'm so sorry. Apologies for this. It seems like
no worry. Go ahead.
My screen. I don't know why because I'm.
No worry. Go ahead because we are.
Sometimes things don't get as we want to. So I'm now go directly to my presentation without my PowerPoint. So as you already informed the other speakers, I will talk about the impact of AI on the criminal justice system in Romania and focusing on the risk assessment tools using AI algorithms. So from the very beginning, I must stress that we are in the midst of a risk assessment revolution in criminal justice. The role of risk assessment is increasingly preeminent at all stages of the criminal justice system, including policing, pretrial detention, sentencing, corrections, and parole. So from the very beginning, I have to point out a very important idea. The risk assessment tools using AI are designed only to inform and not to replace the exercise of judicial decision making of a human actor. And the use of the risk assessment tools has passed a long history starting in 1920, and now we are let's say in a postmodern era because we are using AI in order to assess the risk of the suspects and defendants and the convicted persons in the criminal trial. I will skip over the definition, but I must emphasize that the AI, as has already been said here, AI does not understand. It's not acting like a human. It only recognizes patterns, does not act, but runs an algorithm. That means the output generated by the AI algorithms can contain biases. That means that led the scholars to conclude that the computer systems may become instruments of injustice. And the use of these types of tools in the criminal justice system can lead to inconsistent and inaccurate assessments in comparison with reality, affecting, of course, the rights of suspects and defendants to a fair trial due to the risk of bias. In Romania, we have, let's say, things going a lot slower than in other countries, but still we are using AI in different let's say, relations and stages and areas of social life, including in the justice system, and particularly in the criminal justice system. The triggers that forced the Romanian authorities to be more open to the use of AI were the following. The general trend present globally to use AI due to the obvious advantages of this tool, like objectivity, speed, and efficiency in solving quite any type of task. And the second one is the cooperation with the foreign authorities from other countries like Canada and Norway, seeking the efficiency in managing criminal cases to prevent risks and to protect population. And of course, the pandemic that forced the authorities to be open to digitization and to find solutions involving the use of information and communication technologies to enable specific activities to be carried out. But in the use, as regards the use of artificial intelligence tools in assessing the risk, the pandemic didn't play such an important role. As regards the risk assessment tools using AI algorithms, I must say that they cannot be used by courts, by Romanian courts in criminal proceedings to justify conviction. Even if there is no express prohibition, Romanian law does not provide the possibility of using such tools. The evaluation of the suspect or the defendant being carried out by the judge based on the personal observations, the interpretation of the evidence administered in the criminal proceedings, and the forensic experts' reports carried out in the case. However, for persons in pretrial detention or for convicted persons in the post-judicium stage, adults or minors, these types of instruments are used in order to assess their risk. We have two tools that use artificial intelligence in assessing the risk of convicted persons and persons under probation. One tool is used by the Romanian National Penitentiary Administration. I like to call it the 4 C's. It's C1, initial assessment tool, C2, periodic evaluation tool, C3, final assessment tool, and C4, social reintegration assessment tool. And the second one is used by the Romanian National Probation Directorate, and it's called CERN, Risk and Needs Assessment Scale. As regards the first one, all the 4 C's are generally called tools for evaluating the activity of detainees, and they are standardized tools used systemically for the initial and periodic evaluation in order to identify the main needs, risk factors, as well as the educational, psychological, and social resources of persons deprived of liberty. They are an integrated system of assessments of the identified risks for recidivism, injury, and self-harm, of criminogenic needs, of the prisoner's responsiveness to the recommendations formulated in the individualized assessment and educational and therapeutic intervention plan, as well as of the adaptation of behavior to the specifics of life in detention. These tools are addressed to adults in prisons and hospitals penitentiaries, which are to be assessed by the commissions for establishing, individualizing, and changing the regime for the execution of custodial sentences. The application of the standard tools for assessing the activity of the prisoners, all the 4 C's, is carried out by means of the computer application for keeping records of the prisoners. And they are apparently in accordance with the Romanian legislation. And when I made a small research in order to identify all the law provisions that allow us to use these kind of tools, I identified the main provision, which is the law number 254 from 2013 on the execution of punishments and custodial measures ordered by judicial bodies during the criminal process. According to its Article 40, paragraph 4, the results of such instruments will be considered by the Commission for establishing, individualizing, and changing the regime of the execution of custodial sentences. In other words, according to this special law, the Commission is forced to use the results generated by these tools using AI in assessing the conduct of the convicted persons which serve custodial sentence. We also have other provisions like the regulation for the application of this law, and we have a decision from 2021 of the National Administration of Penitentiaries on the approval of tools for evaluating the activity of prisoners, which made the use of these tools mandatory. I must say that the provisions of the Article 40, paragraph 4 I was referring to previously were challenged at the Constitutional Court of Romania. But by decision 727 from 2018, the Romanian Constitutional Court rejected the objection of unconstitutionality of these provisions, and it didn't take into account the author's arguments for the exception. The arguments were the Romanian law does not clearly specify, yes, I will finish in no time. The Romanian law does not clearly specify what are the standard instruments for evaluating detainees. The criticized text does not contain any guarantees in relation to the control of the application of the system of standard indicators and any appropriate control procedure. The fact that the law does not provide explicitly and in detail the conditions under which the General Director of the National Penitentiary Administration can establish, modify, or use the system of standard indicators means that the authorities can affect the rights of the detainees, especially in such a sensitive area as that of establishing the regime. But the Constitutional Court rejected, as I told you, and ruled that these legal provisions were in accordance with the constitutional standards of the Romanian fundamental law. The second instrument used by the National Probation Directorate is CERN, Risk Needs Assessment Scale, and the use of it is also let's say, allowed by the interpretation of several provisions from Romanian Criminal Code and Romanian Criminal Procedure Code, and also by the interpretation of some provisions of the law on the organization and operation of the probation system. But the foundation of the use of this tool were laid in 2011, and then in 2021, after several tests in the pillar phase, it was decided to use CERN. Nevertheless, all the studies had shown that in several cases, artificial intelligence made mistakes. This led to some scholars to declare that artificial intelligence frustrates through the sometimes different results generated by the calculation algorithm compared to the professional judgment of the probation officers. The problem is that we are forced to use this even if in the post-trial, post-judicial phase of the criminal trial. And regardless of the degree of the accuracy of these tools, the final decision rests with the human actors. The information provided by AI is intended to complete and bring additional elements to support the decision made and not to replace it. But still, the use of the risk score generated by the program is mandatory in this phase. And I think, in my opinion, a lot of research is necessary in order to establish the accuracy of the risk scores, even if they do not interfere with the conviction decision. This was the main argument of the Romanian Constitutional Court, that because it wasn't a conviction decision and solely a decision that sought to modify the execution regime of the imprisonment does not violates the constitutional
constitutional principle. Okay, thank you. Very interesting because you use this kind of tools in execution, in criminal execution, and in the next Congress we'll go in depth about the risks, the real risks. If some defendants how can I say, put in action, come posso dire, contro le autorità criminali, cioè se le autorità di esecuzione, cioè there will be some action against the use of some such tools in the particular cases.
I hope so.
Particular cases.
I hope so, because we have a problem in Romania. These tools are not very, let's say, known, not even by the lawyer, and we have
there is not disclosure and. Okay,
we have a problem
there is not disclosure, there is not training for the defense. We have the same problem.
Decisions made by the, let's say, administrative authorities, which are organizing the penitentiary system.
Yeah.
So
I think we have the
success.
Yeah, we have a similar problem with the tax administrative offices. They will use a lot of AI-empowered tools for the risk assessment in the fiscal sector. Okay, thank you. We are late. So, Adrian Wagner, it's up to you. I said from Germany, Dolce Lauda law firm, Justice Automated, the perils of AI in Germany's legal framework. So you have, do you have legal framework for AI yet, I suppose?
Sorry, no, I meant more like the existing legal framework in the sense of the constitution.
Okay, please,
yeah.
Okay.
Thank you very much, and thank you for the invitation and the opportunity to speak in front of you. I'm going to give you an overview of the state of AI in the German justice system, where it's at, and the issue that arises from this of constitutional nature. In an era where digitalization permeates almost every aspect of our lives, it's of course, the justice system is affected by this as well, and I think we all agree that AI is an especially disruptive digital advancement. In the short term, the application of AI by the judiciary itself could be crucial in handling a number of issues the German legal system is facing. It's under a lot of strain. There's a big issue with staff shortages. And of course, on the other hand, issues arise because of the AI is facilitating the access to law for everybody, basically, which leads to an increase in cases in front of the courts, which increases, again, the strain. This poses a number of questions, especially those of a constitutional manner. According to Articles 92 and 97 of the German Basic Law, this judicial decisions must be made by human judges, obviously, and substituting judges with software is constitutionally impermissible. So the question that arises from this is how far can the influence of supporting AI applications go before, so it's, how do I say it? So the decision is still a human one.
In human.
Yeah.
From judge, from human, from judge.
Yeah, from the human
responsibility,
judge.
the judge is in charge of.
Yeah.
Remains in charge of.
Yeah. So additionally, based on experience from the Nazi era, the basic law in Germany mandates that the judiciary, there's a emphasis in the basic law on the fundamental notions of fairness, which kind of contradicts the use of an algorithm for decision making that just follows rules blindly. The judicial process in this sense does not only involve logical considerations, but also human emotions and such things as empathy and care. So before this, in front of this framework, there are actually already applications in use in German legal system. Especially important are those in mass litigation cases, such as those related to the diesel emission scandal and air passenger rights in Frankfurt. The Higher Regional Court of Frankfurt, as well as the Higher Regional Court of Stuttgart, do have their own pilot projects. These are systems that use machine learning to extract relevant data from case documents, thereby accelerating processing, which is a prime example of how AI can take over routine tasks and thereby increase efficiency of the judges. The conduct of those manual reviews of facts in those bulk litigation cases is an enormous task. A lot of those submissions extend to more than 180 pages, and a lot of it is very similar, and so it's a tedious and resource-intensive task for the judiciary. So the project that the Higher Regional Court of Stuttgart, which is the one that deals mainly with those diesel cases, does this sorting task. It sifts through the vast amounts of data in the digital records to extract only the necessary information for sorting. The software is capable of identifying decisions, facts of the case, requests. It navigates through texts and evaluates their relevance. It then examines the judgment from the first instance, the justification for the appeal, and the counterstatement to the appeal, scanning for judge-defined criteria such as type of vehicle and engine, mileage, price at purchase. Subsequently, then it organizes the factual situation according to these criteria into groups that mirror the case law of the Higher Regional Court of Stuttgart. And by utilizing these criteria, then the judge can precisely search for, display, and manage related cases in a more focused or collective manner. And thus, it's mainly an investigative tool that is governed by judicial instructions and does obviously not render any verdicts of its own. Then it also incorporates pre-existing draft rulings and by identified criteria at relevant sections, custom fitting them to the specific cases and plaintiffs. The one that's the program that's used by the Higher Regional Court of Frankfurt is very similar in that case. It's capable of automatically extracting relevant case data relating to the flights and the departure and destination, and thereby groups these. These tools are reported to increase the work efficiency of the judges that employ them by 75%, which is really quite a bit. And as such, will probably be very crucial to alleviate the strain on the German justice system. As I said, they are fighting a lot with staff shortages. And at the same time, I already mentioned that by facilitating the access to the citizens, the lawsuits increase and there's even more strain. There's there are other applications like in Bavaria and Baden-Württemberg, they use AI to identify personal data and decisions in order to suggest anonymizations, so they can be publicized. The publication rate, as it is now, of court decisions in Germany is at about 1 to 2%, which is really not a lot, especially considering that there's a legal imperative to publicize decisions, obviously also in an effort to facilitate access to law.
Okay.
And
yeah.
Sorry?
No. You have just 2 minutes more.
Okay.
I'm sorry for my role. I can deny my role.
Yeah. So, even in the cases where software merely supports judges and partially makes decisions for them, as I just illustrated, there are high requirements that must be met, foremost due to the judicial independence. Because if automated processes influence court decisions, it's only compatible with judicial independence if judges fully understand the software's functioning, possibly through public certification and using software that operates as a black box to the judge, where its internal processes are not understood, is really not, it doesn't work in this, like it's not permissible. It's not, it's a problem in regards to the judicial independence, because you can't make, as a judge, you can't make an informed and conscious decision if you don't really know what's going on, if you don't know what the information that the application is delivering to you, how it got there, and the reasoning behind it. So AI literacy of judges will be imperative in ensuring in employing AI tools that is in accordance with the Constitution. This still works with those tools that I mentioned earlier. They still have, while they do employ machine learning to varying degrees, they still operate on clearly defined and understandable parameters. But the deeper we get into deep learning, and the more this will become an issue, obviously, because with more advanced AI applications, even the creators often don't really know how or even why they function. So these sort of black box solutions are fundamentally incompatible with the current legal framework in Germany. And
okay.
Yeah, I guess I can wrap it up there.
Now, which is the feeling of that German lawyers about AI? Is a good feeling or a bad feeling or fear in general?
It's probably it's a mix of all of that, I guess.
As Italian. Okay, thank you, Mr. Wagner. Now, Federica Federici, the president of New Frontiers of Law. Are you with us or not?
Yes, sure.
Okay, okay. Allora, Mrs. Federici will talk about predictive justice, if I write, opportunities or threats. Please, the stage is yours.
Thank you, Claudia, for moderation. Thank you to Rosanna and Prof. Viola for the wonderful and professional organization of this Congress. And thank you especially to Luigi for his strong effort to develop this issue since many years in unsuspectable times. He began to speak about this. So today is only another occasion that he presents to us, to everybody, to share knowledge and expertises. Thanks to the audience, still now connected, for spending time to get knowledge and competencies about predictive justice and artificial intelligence in this hour, in our digital age, where the use of the advanced technologies has become a new paradigm of the justice system. There is much interest about this issue, but also much confusion about this issue. So I tried to, in few minutes, understand what is common to all countries and systems about this situation. We need to continue on one side to make a critical evaluation and research based on an optimization and implementation of the predictive justice and algorithms and artificial intelligence. But on the other side, we have to accept, finally, that algorithms and predictive justice and artificial intelligence are a real commitment in many dimensions. So we must analyze and compare different expertises and tools. It's fundamental, this, because it's the only way to go on and not to spend times in make only theoretical dialogue. So one of the main problems for an effective prediction, especially in Europe, in a predictive justice, is the legal domain that is a limited availability of data, of relevant data. So we need to collect as many data as possible to make a scenario much certain as possible. So we have to find out a method and an approach that reconciles the machine and right. Another problem is the ethical perspective, to avoid algorithmic discrimination or damages and not benefits. So there is a risk of an excess of self-referentiality by the judiciary power and judges. Don't forget that the predictive justice is a duty, but it's also a social good. It's a social good called to serve justice as a fundamental right. It's really ambitious, it's innovative, it's practical, it means progress and a human right goal. So in the international scenario, the ambitions are very many, and many are multiple and transversal, because the decisional process using technologies must be neutral, certain, and correct, without replacing, and Luigi is very, very strong on this, without replacing totally the legal reasoning led by judge or lawyer, by the human agent. So artificial intelligence and predictive justice must serve the efficiency of the justice, the quality of the justice, becoming more certain and scientific as possible. So we need to reach a level of security, of accuracy. We have to export and import knowledge and techniques. We have to find out solutions across many disciplines. We have to make protocols to define guidelines, to automate the pseudonymization of texts, to create innovative tools based on data science. We have to adapt our needs, our abilities, and all of the end users. We have to apply an interdisciplinary approach. We have to create an ethical approach, a legally compliant infrastructure that is ethic, but innovative, but efficient at the same moment. We have to simplify access to records that are really limited. We have to automate case law research activities. We have to reduce costs of justice system, because our goal with artificial intelligence is to reduce risks and costs. We have to create a network, a really efficient network. And at the end of all, we have to enter in a new constitutional law in the cybernetic era. My conclusion is that we have the risk, it's real, the risk of produce incorrect explanations of legal decisions based on statistical correlations. But together, we have also the risk of discrimination and the risk of non-explore the subjective interpretation. So we need to reach a statistical jurisprudential approach based on a suitable data set created by the artificial intelligence that is our tool and our main tool to get a really correct and neutral predictive justice. Predictive justice is, first of all, a philosophy. Today I heard about all of you, and it's a really complex scenario, a really interdisciplinary scenario. So we have to accept that we are entering in a new era, in a new age, and predictive justice is really a philosophy for lawyers, for judges, for doctors, for scientists, for social scientists that are called to draw boundaries. Our goal is to make and to share all together boundaries between the consistency of the interpretation and what is unpredictable in the justice, with a regard to a poor emotional evaluation. We need to continue to study, and Luigi is our light in this, because we have to study all the potentiality and limits as well, without prejudice, fear, or suspicious, as Claudia told at the end of the previous intervention. Thanks to everybody.
Thank you very much, Federica, for your suggestion to be proactive, not denying the core business of the lawyers or the jurists, that is the legal reasoning, as Luigi Viola remember us every time. So thank you very much. And before leaving the stage to Pierluigi for the conclusions, I want to extend my deepest gratitude to each and every one of you for your invaluable contribution. Thank you so much. Thank you to Luigi Viola, and Pierluigi, the stage is yours for the conclusions.
Thanks, Claudia. Thanks for the participation of everybody. Thanks to Rosanna Marzocca. I just compiled the full block of notes, really full of notes. But of course, given the time, I will just give you some sentences that to me has been key in highlights of this. And there is a lot of work done that is being doing in the intersection between technology and law, and there is still a lot of work to do. And this is good because there are pioneers that are creating law cases, creating jurisdiction on things that maybe 1 year ago was unbelievable. Important to say that law professionals don't give the back to technology. They want to use and to understand the technology to make a better use of it. And of course, we need to counterbalance AI models that are statistical parrots with the natural stupidity. These have been really beautiful. Thanks for this balance. So another important message that I got is that technology should not and will not replace humans, but will integrate, complement, and speed up the value chain that humans are providing in all the sectors as before, but I can see this message also in the legal sector. And I close with one sentence, and I'm an engineer, actually. I'm not a lawyer. I didn't study law, but Judge Ledesma from Argentina quoted this sentence that the lawyer of the future will be called legal engineers. And with this, I give the floor to Luigi Viola for the final greetings. Thank you, and see you tomorrow.
Thank you your participation. See you tomorrow. Bye.
Bye. Thank
Bye.
you. Thank you, Rosanna.
Thank you, Rosanna.
Grazie a voi, grazie Claudia, grazie Luigi e grazie anche per Luigi e tutti i relatori. Thank you all the speakers. Thank you so much. Bye bye.
Un'informazione di servizio. Possiamo chiedere le slide?
Siamo online ancora,
Ops.
Prego e buonanotte.
Buonanotte.
We will ask for the slide and publish. Buonanotte.
Okay. Bye.
Bye bye.